You are in the panel, sir.
Yes. Want to mention?
No, this memo.
What is that?
Memo for posting your lordship.
Pardon?
Memo for posting your lordship.
What is that, ma'am?
Lordship, this is a memo. This is an habeas corpus petition. I'm filing a memo regarding this to clarify the.
Is it a pending habeas corpus?
Yes, lordship.
Okay. What is the date there?
Lordship.
Is any date there?
No, lordship.
Ma'am, is it an old one?
Yeah, file I give it. Date is not valid.
Already it has been fed and no date.
No, what do you want? The objections are there.
Yes, lordship. They have filed an objections. A respondent.
Huh.
Lordship, it is a matter regarding the jurisdiction of trial court. The incident happened in the Hubli Dharwad. The cognizance has taken by the Bangalore Special Court, that is NIA court. But our contention is the special court cannot take the cognizance as per the NIA Act. It was section 11 and 22 difference.
When did you file it?
This
Did you file the petition?
in the month of May, your lordship.
It's not been listed.
It's listed, Lordship, but
And was it listed?
last date it was listed in the month of this month only.
What is the date?
I don't remember.
No date. Someone appeared for the respondents?
Yes, Lordship. Already, the Honorable Coordinate Bench is directed to file the objections, Your Lordship,
They have said so. So when do you want to be listed?
in this week, Lordship.
No, we will see. Just see. See next week. But you have to inform the other council.
Yes, Lordship, Government Council.
Yeah, you have to take the acknowledgement, tell him the date of hearing also, so that he can be present.
Grateful, Lordship.
Sir, 5/8.
5/8.
May,
Great,
may,
Lordship.
may make one submission.
Ma'am, admission matters has to be mentioned before the Chief Justice.
Only.
Here. When do you want? Just see your date. This is 23 writ appeal?
Yes, ma'am. Yes. It is not posted for admission. Madam, this is one 2018 matter, madam. It is merge of retirement of petitioner. Madam.
Yeah, we'll list it. We'll list it. Which is, this is another one.
Another one, madam.
Just take it.
2018. madam.
No, 2018 is not here.
Notice CAT, service CAT.
CAT.
Yeah.
Okay.
Central government, central government.
8. Endorsement on ನಮ್ಗೆ ವಾಪಸ್ RFA ಇಲ್ಲ.
You inform the other side about the date also so that he can note it. Then give it to the court officer.
My lord, this is long,
Adjourn.
very long pending, my lord, this is 27.
Pardon?
Long pending case, my lord.
What is the year? Which, is it a writ appeal or a writ petition
Writ petition.
from the CAT?
Yes, yes.
Let's see. There is no date here. No date.
Date I put, my lord. Date of
What is the next date of hearing?
19th August.
So the next date ಇದೆಯಾ sir?
19th August.
Next date is, requested for requested. What is the issue?
Issue is notion. This is MACP, my lord.
Huh?
MACP.
MACP. What is the urgency?
My lord, it is 22nd.
Okay, listed there. Just give a date. 19th, he said 19th, ma'am.
19th.
See the last column, 19th.
Yes, sir.
Right.
Requested date 19/8 sir.
Huh?
19th.
8. You want 19th 8? Why so long? You say
19th.
urgent.
Early date also will do, my lord.
Okay, just give any date convenient. But you have to inform the other side.
Yes. I will.
Just take them.
Okay.
For adjournments. Page number 6, 23 to 25.
Bill number 23, madam. And for the appellant, I grant 1 week accommodation. For the reason, personal increment.
You are for whom?
I am for the appellant, madam.
You are for the, this is 23 special director? No.
Yes, madam. Enforcement, no, I am for the appellant, Chandrasekhara K. madam.
Who is the other side?
There is
Jeevan
Jeevan Neelargi is not in the panel, madam. Kindly take a mention, Madhukar Deshpande appearing on behalf of enforcement director. Now it is.
So Deshpande here.
No, madam.
You are the colleague of Mr. Deshpande?
Yes, madam.
Already served a copy to the. Madhukar,
What is the reason for adjournment?
but I am not feeling well. I am not ready.
But you will look into this. I think the one, Mr. Jeevan Neelargi was appearing.
Look
Just,
at it.
just look into that. Possibly the request for adjournment is made on behalf of the, by the counsel for the appellant. Full stop. We have been informed by the counsel for the appellant, Mr. Jeevan J. Neelargi. He is no more the panel counsel for the respondent, Full stop. Mr. So-and-so who appears, who is the colleague? You are the colleague of
Yes,
Mr.
ma'am.
Deshpande?
Yes.
Mr. Deshpande, the standing counsel for the respondent, shall also take instruction from Mr. Deshpande for appearing for the respondent.
Yes.
Full stop, re-notify on.
12-8,
Sixth, my lord.
Ma'am, just say this. We'll just give our convenient also. Say that
12-8, sir.
adjournment is sought on the ground. He is not well. He is not well.
Sixth is convenient for us.
Pardon?
Sixth is the convenient for. Engage.
See the other date also. We have to see our board also. Which is the other date?
To 28, my lord, my senior, engage service of senior counsel.
6-8.
Six. Please.
Does 6 permit us? Huh? But okay, give it. 6th August.
Much obliged. Please.
Page number 7, 26 to 34.
Serial number 28, my lord.
Submission, my lord. Serial number 33,
Due
my
to
lord.
family emergency, my senior counsel has gone.
Which number?
Serial number 28, my lord. My senior counsel has gone to NATO in the today morning, my lord, due to family emergency to his native. So kindly, next week, man.
Adjournment is sought by the
is-
counsel for the appellant on the ground that the arguing counsel is out of station. Re-notify, just say,
Right.
next week we can give.
7-8,
My lord, serial number 33, my lord.
for serial number.
33, my lord.
Sir,
I
one
appeal
nimsham.
for the petitioner, my lord. I have filed another 3 connected matters, my lord. They have been admitted, my lord.
That
And
43.
I kindly
sir.
have this matter next week, my lord. Next week,
He is mentioning which matter.
Sir, serial number
33.
33. 33,
yes.
sir.
I am mentioning 33, my lord.
Shri Prabhakar Rao,
Yes, my lord.
33, sir.
What is the difficulty, Mr. Rao?
Lord, along with that, the other 3 matters have been filed, my lord. My friend is also appearing in the same matters, my lord.
Pardon?
Along with this matter, my lord, serial number 33,
Yes,
there are other 3 matters which have been filed. in the-
connected matters.
Connected
When-
matter.
when
My
are they
friend
coming?
also knows about this. They have not been listed, therefore I will see that the registry matters listed by next week, my lord. All the 4 matters can be taken up.
Okay, just give it next week then.
The lead matter, I'm appearing for the Keveta respondent. The lead matter is listed on 1st of August.
He's saying the other council is saying 1st of August.
1st of August, my lord, I have some personal inconvenience. There is a
You
family.
tell us one thing. He said there are 3 other matters.
All the matters, there is one lead matter in which there's already, my lord, some order passed. These are the connected matters which are getting listed.
Okay,
Your lordships may have it on, my lords, the 1st of August so that all of them can be tagged
No,
along.
1st of August, Mr. Patel. The 1st of August, I have some personal inconvenience. We will have it after
Very
5th.
Very well.
very well.
Six.
Just see, when do you want?
My lord, after 5th, any date which is convenient to the court, my lord.
Just give it any date after that. But ensure it, the other matters also come for hearing.
Yes, my lord.
Sir, 12-8, sir.
Very well.
Very well.
Great.
My lords, serial,
12th of August.
Grateful, my lord.
my lord, serial number 37, my lords, I'm for the petitioner. The arguing counsel is traveling for family emergencies, my lords.
No, it's an old matter, ma'am. We should
Please,
not
my lord.
adjourn it.
My lords, any short accommodation, my lords, by 30th, 31st will be able to. argue.
Tomorrow, 30th is tomorrow.
Please, my lords, tomorrow is
We'll
also
have
fine.
it
30th,
tomorrow.
31st is also.
We'll have it tomorrow.
Please, my lords.
At the request of counsel for the petitioner, re-notify tomorrow.
Well, it's serial number 36 minutes.
Pardon?
Serial number 36 minutes.
She
And
mentioned
for the
36
respondent,
only.
my
37.
Oh, sorry, my mistake. Yes,
minutes, I'm for the respondent. My apologies, I haven't informed the other side. But I have to file objections. It's ready, my lords. It's only pending for
objections.
signatures of the officials.
need for objections. You have filed the objection before the tribunal. You are appearing for whom?
For respondents, my lord.
Which respondent?
1
ITI.
to 3, 1 to 3, all the 3. My lord.
We will hear you. We'll hear you. Just wait.
My lords, it's already, it's just pending for signatures.
Doesn't, yeah.
Just a short
Yeah,
accommodation.
Most like a first appeal.
Please, my lords.
There are objections are there before the tribunal?
That is there, my lords, but
We will look into that. We'll look into that. Just wait.
Serial, lordships kindly, serial number 27, my lord. Respondent is served, nobody is appearing for respondent. Pray for a week's accommodation,
It's all right. If they are not appearing, they are not appearing.
Yes.
We'll look into it.
please. Wanted a week's accommodation.
It's all right, Mr. Swami.
Lordships, serial number 9, the senior counsel is not available, he is traveling. So therefore, a request for short adjournment. 9.
What is the difficulty?
9 is an order, sir.
Hmm?
9 is in orders. Non-compliance.
Pardon, ma'am?
Is in order.
You can argue. You appear for whom?
For the appellant, you know.
Just wait, just wait. You call the matters.
One. Government advocate.
A week's time may be granted, my lord,
For what?
for complaints.
Just show me the file. You appear for whom? You
Statement.
appear for whom?
Lords, I appear for respondent number 2, 4 and 5, my lords.
Now, who is not served?
3, my lord.
Is the UPSC, my lords.
How is 3 is relevant, tell us. And mind it, 6 is served,
Yes, my lord.
6 is also secretary, the same UPSC. I don't think you really, you are ready for arguments?
Lords, I support the appellants, my lords, petitioners. I am ready, my lords.
No, you appear for whom?
For respondent number 2, 4 and 5, my lords.
Achha, you appear for 2, 4 and 5.
Please, my lords.
Who appears for 1?
My lords.
Lords, I appear for the respondent number 1, my lords.
Okay.
I am for the respondent number 1 in this matter, my lords.
Then what the service, I don't think
Lords,
service is really required.
Service, my lords, and there is one office objections, my lords, which has been raised.
But
Lords,
you are the
wherein we have
contesting
arrayed-
party.
Please.
You are the contesting party.
I am the contesting party, my lords.
That's all. Why do you require all of them? The contempt alleged against the appellants. That's right.
Please, my lords.
The contempt is alleged against the appellant. The other respondents have nothing to do.
The other respondents have not challenged the order, my lords.
It's all right. And they
Yes.
are basically the grievances of the state.
Please.
Now, what do you say? Are you ready?
My lords, a short accommodation, my lords, petitioner has to address in the first instance, my lords. Today it is listed for orders, and there is non-compliance and non-service of notice. It was listed today, my lords.
Tell us how is a contempt maintainable? They have
Lord,
passed an
I'll
order.
address-
They passed an order. You will challenge it, the fresh order.
My lords, a short accommodation may kindly be granted, my lords. I shall come and justify, my lords. Today it is listed for orders, my lords.
Yes, we'll have it tomorrow.
Lords, tomorrow, my lords.
What is it?
Lord,
See,
sir.
it's a short. The contempt, the order passed cannot be a subject matter of contempt. It should have been fresh proceedings.
No, I shall justify, my lords. I shall justify, my lords.
So we'll have
10
it
days
tomorrow.
time may kindly be granted.
Re-notify
Not-
tomorrow and just look into this observation of ours.
Lords, tomorrow,
And come
tomorrow there
tomorrow.
is some inconvenience, my lords. I will have to travel from Dharwad. A date may be fixed, my lords. Next week I shall come and address my arguments. my lords.
No need. You appear virtually. What is there?
No, my lords, I have to come personally, my lords, kindly. Next week, any date, my lords, may kindly fix, my lords. I shall come and address my arguments.
June Monday,
5th of August, sir.
5th August, Monday,
Can I request for 6th, my lords? 6th,
6th.
6th, I have 6th of August.
6th of August, sir.
Grateful.
At the request of counsel for the respondent number 1, re-notify on.
Interim order of extent, my lord.
Interim order if any to continue.
Serial number 2, Shri Keshavamurthy.
Before the. Which are the appeals? This is on this. We have posted it. So we do one thing, we notify. That year.
So many matters.
23. 23.
22, 21.
Sorry.
So
This- Say so. Means some other work is also posted today.
Saturday and tomorrow also. Tomorrow also. Tomorrow.
Tomorrow.
Okay, sir.
This judgment. Ah, no. This- We do one thing, we just have it tomorrow, we notify, then we will see.
Hello. Serial number 3. Shri Dhananjay Kumar.
Appearing for appellants, my lord. A week time may be granted to comply the office objection.
What are the office objections?
Yeah.
How many are there? 15 objections. Ma'am, this should be last opportunity.
Yes, my lord, we will
As a
comply.
last opportunity, 3 weeks are granted to remove the objections as notified by the registry
Obliged.
after 3 weeks.
21st August. Madam, 21st August. Serial number 4. Serial number 4, government advocate.
Week's time may be granted, my lord.
A week's time is granted to remove the objections. As notified by the registry, we notify all.
6-8. Serial number 5. Shri Amar Gowda.
For 1 week time, no, we'll have it tomorrow, this matter. Re-notify tomorrow.
30th. Serial number 6, Shri Rajendra MS.
This also same tomorrow.
30th.
Comply, my lords, I was required to produce 2 books. I have procured and I have brought those books today. In the due course,
Then,
in the due course, I will give those books to the Advocates Association Library.
you get it tomorrow.
Please,
We'll have it tomorrow.
please.
Objection ಮಾಡ್ತೀವಿ ಅಂದ್ರೆ. 7. Serial number 7, Shri Prasad BS.
2 days time to complete the office objection.
What are the objections?
Sir, there are delay affidavit, my lord, allow. And translation copy also filed, my lord.
The word is which?
Cheat issue. You do one thing, okay. You are for the appellant?
Please.
Let objections be removed within 2 weeks. List on.
12-8.
Please.
Serial number 8, Sri Murugesh Charity.
My lord, pray for 1 week to compliance, my lord. Translate copies are ready, my lord.
Objections be removed within 2 weeks, re-notify. You have to deposit the court fee also.
Please. we
You
will
appear
file.
for the respondent.
Yes, miss. I filed wakalat without, officially notice was not ordered. I don't have a copy of the writ appeal. My lord, sir, my friend has told me that after they comply, they'll serve me a copy.
You are the contesting party.
I'm the contesting party. I was the petitioner, my lords, before the writ court minutes.
But ma'am, you have to deposit the court fee, without which we, otherwise we
We
could
will-
have heard it.
We will deposit today.
ಇಲ್ಲ, ಹೆಸರಿದೆ ಇದೆ ಹೆಸರಿದೆ ವಕಾಲತ್ ಹಾಕಿ
How much time?
1 week, my lord.
A week's time is granted to remove the objections.
6-8.
Achi.
Serial number 9, Sri Darbai Venkatesh. 9.
Lordship, appearing for the appellant in this matter, the earlier SPP had resigned and recently the appellant had appointed the special counsel. So therefore, seek 1 week time for compliance of the objections. This is KPID matter, Lordship.
Surprising. What is the difficulty?
The new special counsel has been appointed, Lordship, so
He
he's
states,
also
the
traveling.
learner counsel for the appellant submits that a new counsel has been appointed by the appellant who shall file his wakalat. Who shall file his wakalat within how much time?
In 1 week time, Lordship.
A week's time.
7-8. Serial number 10. Shri Murugesh Charity. 10.
My lord, all objections are complied, my lord. One continuation of delay application has to be filed, my lord. Only
Which
3 days.
application?
Continuation of delay application has to be filed, my lord.
Where is it?
3 days stay may be granted, my lord. We will. 44 days delay, my lord.
Why an appeal against this order? Where is the counsel? Where is the counsel?
My lord, he's held up in other court.
Mr. Charity is there, the counsel, no? Just call him. Pass over.
Pass on. Serial number 11. K.S. Narayan Swamy.
To the applicant in this case, my lord. My lord, I pray for a week's accommodation, my lord, to remove 3 objections, my lord. In the connected writ appeal, all the objections are cleared, my lord. 3 objections is with regard to typed copy and the translation copy, my lord. It is ready, my lord, with me only. I will file within 2 days, my lord.
The objections be cleared within 2 weeks.
Yes.
13-8. 12.
12 and 13, I have to take steps for the unserved respondents. I will take it in 3 days' time. my lord.
Respondent number 1 is unserved or 3 is unserved?
One, my lord. In another case,
Both the matters.
in first matter, 1, my lord.
Huh.
Second is 13, is 4 and 5, my lord.
Second is?
4 and 5, my lord.
Okay.
Take steps in 3 days.
You appear for others.
I appear for the bank, second
The
respondent.
bank. Who appears for the, are they and others also individuals?
Individuals, my lord.
The counsel for the appellant.
I appear, my lords, in serial number 21 for the private individuals. The cause list shows as served. I'll file wakalat, my lords, for those private individuals.
Or in both the matters?
All the matters, my lords. In 21, I filed wakalat for these private individuals. This shows as served, my lords. My clients, I don't think were aware.
We take up 20 and 21 also. 20 is also connected with this, I suppose.
Yes, my lord. 20, 21, 12, 13.
But 20 and 21 notice is complete.
Yes,
My lords, in 21, I think, my lords, for R4 notice is not complete.
they're all family members only. All family members only.
That we can see that. Now we take it 12, 13 and 20, 21 are connected.
Yes, my lord.
All are connected. So the only thing is you have to serve the unserved respondents in 12 and 13.
Yes, my lord.
Just serve them.
Yes.
Would you be appearing for 12, those respondents in 12 and
I'll
13?
just check the area of the cause title, my lords. I'm not appearing.
It from the court.
Yes, my
Ma'am,
lords, I
just
will.
give him the file. Just give him the file in 12 and 13.
No, it's 12. I'm not on Wakalat, my lords. I'm not on Wakalat for this individual.
Instructions?
No, I
on
have
the-
no instructions in 12.
Pardon?
I have no instructions in
No
12.
instructions. So we'll issue notice in 12.
Yes, my lords.
Okay. 12, let notice be issued to the respondent number 1, returnable on. Just give us after 2-3 weeks.
Sir, 9,
What about 13?
I'm just taking a look, my lords. My lords, I will undertake for 1 and 3, my lords. 1, 3, 4. Respondent number 1, 3 and 4.
You will take.
5 notice will have to go, my lords. I don't have instructions from 5.
Though respondent 4 has not been served, comma, so and so appears for respondent number, who appears for respondent number 1 and 3, na?
1, 3 and 4.
States that he shall appear for respondent number 4 as well. He shall file wakalat on behalf of respondent number 4 within 1 week. Full stop. In view of the above, as R5 is still unserved, less fresh notice be issued for service on R5, same date, ma'am.
9.
Yes. And now come to 20 and 21, the service is complete.
20
now
service
we-
complete, sir.
Complete. Okay. Then re-notify on the same date.
Yes.
But you
21.
said someone is still
Lords,
unserved.
in 21 also, I believe.
No, sir,
4 would be.
21, no.
Ma'am, complete?
Yes, sir,
No,
complete.
sir.
Complete.
In 21 services, 2021 services complete, my lord.
Okay. Very well. According to us, report this complete service, same date.
Yes.
2021. Bhargav D. Bhatt, same. Bhargav D. Bhatt. Take notice, madam. Bhargav D. Bhatt. 14, Shayar Kiran.
For the appellant in this case. Pray for a week's time in this matter to take steps and also to file a necessary application to bring the LRs on record.
He is unserved here.
Sir, 3, sir.
That notice be issued to respondent number 3, returnable on.
23-9.
Ublesh.
15. Srimati Shirish Krishna. 15.
For the petitioner,
Yes.
your lordship, we have taken steps
What?
of against respondent number 1, your lordship.
File, ma'am.
Team 7 dispatch.
Who appears for the respondent? But your respondent number 1 is still unserved.
Mr. Lordship, but we have taken steps.
What about 2 and 3?
We have-
R1 to R3 matrix, sir.
Oh, let notice be issued to respondent number 1 to 3, returnable on. No, what is the date of it?
Team 7 they have dispatched.
Oh. No, we'll issue fresh notice, man. You deposit the process fee afresh. We'll issue fresh notice. We'll give you a date fixed.
Very well, your lordship.
Let fresh notice be issued to respondent number 1 to 3, returnable on.
24-9.
Now serve them.
4-9. Serial number 16, Shivek Holla.
Translation, in the judgment, my lord, I am told, my lord, there is some small paragraph, my lord, in Kannada. The translation, my lord, we are. Page, my lord, 23. There is one, my lord, noting in Kannada. The translation, my lord, we are furnishing.
Good morning.
No, which is the translation? Let us see.
Here, my lord.
Otherwise, complete, now you are appearing for the appellant.
Yes.
Okay.
Respondent served,
No, sir. it's-
not
No,
served.
my lord, notice has not been ordered.
Which is the document, Mr. Hola?
My lord, in the order of the learned single judge, he has culled out, my lord, one portion at para 23.
If it's not a big observation or a big paragraph.
No, my lord. But anyway, my lord, we have given you the translation also. Page 23, my lord.
Tell him, Mr. Hola, is it his case that he could not have been transferred to Noida?
My lord, he has not even challenged the transfer order. What happened was, my lord, 6 months he did not come.
Then became the subject matter of an inquiry.
Yes,
That
because,
he has challenged.
yeah, my lord, he did not go there
That's
and then did not, my lord, attend for 6 months. At least, my lord, he should have given. Transfer is not challenged, only his termination is challenged. And my lord, he has initiated contempt proceedings now. In fact, he has initiated contempt proceedings against Swamiji because unfortunately, Swamiji is the head of the, my lord, the
Now,
trust.
No, but he has challenged he has filed a contempt against this non-compliance of this order.
Yes, of the learned single judge's order.
A single judge.
My lord, the inquiry was upheld by the EAT. That's the, my lord, the tribunal, my lord, there's a educational tribunal, my lord, constituted by, my lord, under the act. District judge, my lord, it goes before this district court. He has upheld it. Learned single judge, my lord, holds that, my lord, though, my lord, transfer is not challenged, the 6 months, my lord, he doesn't come at all. And he is, my lord, does not produce the medical certificate. He says, I was not well. No medical certificate, nothing.
But then we'll issue notice to the respondent.
Only thing is, my lord, he has initiated contempt against the Swamiji.
But where is the stay application?
My lord, can I persuade your lord, says, look at, my lord, page 260, my lord.
Just say this. What is this?
That's the translation, my lord, we have given to your lordship, my lord.
Mr. Hola has filed on record, filed a memo placing before the court the English translation of the Kannada version of the impugned order. In the impugned order. Full stop. The same is taken on record. Full stop, issue notice. Full stop, during the course of hearing, Mr. Hola would submit that the respondent herein has initiated contempt proceedings for non-compliance of the impugned order. Full stop, noting the said submission and also perusing the record, comma, the operation of the impugned order dated so and so, that is 3rd October 2023. Shall in writ petition number 1745 of 2011, bracket S-RES shall remain state till the next date of it.
29. Seventeen.
That's a PM.
Yes, tell us. What is the issue?
Matter relates to removal of the petitioner.
One submission, my lord. Here I filed the MA for respond number 1, my lord. I take notice to all the other respondents also and.
Yes, 1 minute. Let's see. Yes.
That matter relates to removal, my lords, of the petitioner. Let's if your lordships, my lords,
What does the tribunal say?
let's tribunal has upheld the removal. Let may I fairly
Tell
state.
us one thing. That's right.
Borderline case.
You must state fairly only.
Borderline case. Borderline case.
He has done half of the thing.
But there is one issue, my lord, which of course I have not taken it in my writ petition. But there's something that I just came across. May I just draw your lordship's attention to the articles of charge? I'll just.
You are Mr. Prithvish. Mr. Prithvish, tell us one. The law is settled now. What is that little window you have?
Absolutely.
Show us that.
May I just draw your lordship's attention to page 75. This is an argument which till today, my lord, I was not aware of. Recently, my lord, for another case which I came across, and when I saw this, my lord, there, page 75, my lord. My lord, the articles of charge is issued by the senior superintendent of post office. Now, my lords, the enquiry report and the enquiry officer, my lords, is the inspector of post, who is below the senior superintendent.
Inquiry officer?
Please.
He is the disciplinary authority.
My lords,
senior superintendent.
No, kindly see, my lords. That's right, my lords. Now, the person, my lords, who is appointed as the enquiry officer is in rank below the person who was framed.
Has to be that way.
No, my lords. May I just, the reason why, my lord, the award, my lord, this honorable court, my lord, which is now confirmed by the apex court, I'll just place that also, would say is the lower cadre officer cannot be expected to overrule the findings or the opinion of the senior officer. There is an element.
Who would overrule? Who would overrule?
Enquiry officer could not possibly say that the articles of charge framed by a senior officer.
See, he will not say in air. He has to say that, look here, this is the evidence and the charge is not made out.
That's right. Now, let's kindly see who the witnesses are also.
We will not examine all this, Mr. Prithvish.
I'm only on the question.
Who will show it's a perverse finding. We will with you. We are actually with you on this.
Please.
Okay. And if you say so, that the authority who issued the charge sheet is he, but the authority who dismissed him or whatever removal is a different authority, not the competent authority. You argue these two.
Please,
still, scope is less.
Very, very, very little, my lord. I'm essentially, my lord, I have raised only 3 contentions.
And what are the charges?
My lord, I understand. My lord, 3 things that I have raised. One is, my lord, insofar as disagreement note, your lordships are aware in Kunj Bihari Mishra, so on and so forth. So, insofar as that charge, the disciplinary authority possibly could not have straight away said that we disagree with the findings. Probably I should have been given an opportunity.
It should have been a provisional view.
Please, my lord. But that would only be to the extent of charge number 8. My lords, the second, my lords, ground that I have raised is, there were 2 documents which were marked in the inquiry. The CCS rules would say that if you are marking documents which are not a part of the articles of charge, then you will have to give him an opportunity, give it to him in advance, give him an opportunity and thereafter mark it, which doesn't appear to be the case.
But those documents were read into? Those documents were read into, were read in the evidence?
Those are marked in the evidence. Did I object to it? Yes.
And you have, no, but tell us one thing, you had those documents with you also?
No, my lords. Those were marked for the first time in the evidence, which was not a part of the articles of charge. And I've stated those, my lords, which are those documents.
And the finding is on the basis of those
documents. Those documents are relied upon to arrive at the findings.
And not given to you?
No.
Show us that.
That ground, my lords, I've taken in my writ petition, which your lordships, my lords, would.
Yes.
Let's
tell us, Mr. Pritish.
That would be exhibit 37, my lords.
You will straight away come to the inquiry officer's finding.
Please, my lords. Exhibit P38.
You said exhibit, you said those were marked.
That's right.
Early.
Exhibit P38 was the document which was examined, which was marked through one Mr. Jairam Shetty, who was examined as PW27.
Okay.
Your lordship will find the inquiry report at page number 136. Could your lordships kindly pass over so that I can come back to your lordships?
Just check up 2-3 things.
Please.
One, you will show, you see, you are saying it is exhibited.
Please,
That means the author must have come to prove the document.
please,
That's one.
yes,
You will see the proceedings of that date. That
please,
when that was produced.
please.
Was the right of cross-examination given to you?
To that extent, yes.
We'll still pass over.
Yes.
Pass over.
And on the disagreement note,
Pardon?
and on the disagreement note, that would be my
The only trump card.
that's why I said it's a very, very little borderline case that I have before you.
See, as long as, you know what, you are not challenging the findings.
Please.
Being perverse.
Perverse.
Scope is little.
Very, very little.
Just check up that.
Yes.
You want to take a passover or shall we?
Pass over, my lord.
Pass over.
I'll see if I can.
We'll have
be
a
of-
passover, we'll pass it over.
Very well. May I come back to your lordship by 2:30?
Yeah, you come at 2:30.
Great.
18, Shivnai,
Lords, I appear for the petitioners, my lords, in this matter. Lords, at the outset, if I may fairly submit, my lords, there appears to be some change in the law that may inure to the benefit of the respondents. Lords, the respondents, lords, are served in caveat. In fact, the matter, my lords, at seal number 18.1 is a lead matter. Lords, my learned friend had entered appearance there as well, and he appears, my lords, in all the matters. They're served in caveat, my lords.
Yes. See, that's, his case is of 17, na?
My lords,
The change in the policy.
no, my lords, subsequent to the interim order, my lords, I'm informed, my lords, that there is a very recent change that may inure, my lords, to the benefit of the respondents. Therefore, my lords, I'm bringing it to my lords' notice.
Is that?
Lords, there's some change in the clarification, my lords, of 2021. There was a clarification, my lords, of
What does the
27/4/21.
clarification say?
That clarification, my lords, I'm told is revised. I'm yet to receive a copy, my lords. My only request, my lords, is my lords may fix a date anytime, my lords, week after next. I'll produce a clarification before my lords, and
That will inure to his benefit.
it would, my lords. I'm told it would inure to his benefit.
But I have copy of that
It was,
Yes.
Lords, there are two connected matters as well.
it's all right, that we will deal it when they come.
Now
Now
the,
tell us,
now the department has decided to implement the tribunal order. As per para 2,
so what it says is para 2. All application for interchange transfer in respect of which NOCs have been issued by recipient region before 22/12/20. And it is a case in this. It is before 20, the NOC.
It is, my lords. In some of the cases, my lords, my only request is I'll ascertain, my lords, there are in fact two other matters that are not on board today on the very same issue, my lords. And
But those would also be governed by these.
they would also be covered by these, my lords, but there appears to be some condition of an affidavit undertaking in para 4, my lords, of the said order. So, my lords, I'll take clear instructions in this regard, my lords.
See the next page. See the next page. In this, directed to require willingness and otherwise writing it proceed further, this is may be obtained from the officer officials, and in case the officer is willing to fresh undertaking the form of affidavit in stampable with the same declaration condition. This is with regard to possibly with regard to the seniority.
Lords. So there has been, in fact, a plethora, my lords, of cases after they join a recipient region wherein they claim seniority. It is in that view, my lords, that I'm making just a request, my lords, for a short accommodation. In fact, my lords may also connect two matters that are not on board today. My lords may finally dispose it. I have no inconvenience.
Who have filed those matters?
I've filed those matters, my lords. I'm the counsel for the petitioner in those matters as well, and I believe, my lords, that my learned friend appears in the caveator and is served, my lords. My lords may just connect the matters, and my lords may fix a date, and we may.
See, now this would get covered. has been issued, recipient, all such applicant of them may be relieved. If the NOC has been issued, all applicant interested. So NOC here was issued before this cutoff date.
Yes, yes. In all these cases.
24/9/20. 24/9/20 is the NOC here. That is before this date.
Lords, it is varying dates, my lords, in different petitions. My only
So far as this case is concerned.
18, my lords, seal number 18. There are
That's
four
right.
matters listed, three matters listed today, my lords.
Today, yes,
Three matters are
we
listed.
will see that.
Lords, there are two more, my lords. It may ultimately be decided together.
We have to see the other, show us the other matters now. So let's not adjourn it.
Lords, may fix a date, even if it is, my lords, in a week's time,
When is the NOC in the second matter?
Before that prescribed date.
In all three matters,
Yes,
NOC was before that date.
Yes, yes.
That's it. He is not questioning the seniority. He is only questioning, we'll pass over, just have a look. We'll just pass over.
oblige, my lords.
Okay, just have a look.
Lords, the seniority, my lords, may make a submission, my lords. What happens, my lords, is the seniority, my lords, is usually what is seen, my lords, from past matters in these sort of intercharge transfers. Is that, my lords, after reporting to the recipient region and thereafter they proceed to charge the seniority. They challenge the seniority. Therefore, my lords, this affidavit system, I believe, is introduced, my lords, in the.
You will still follow an affidavit system. We are not foreclosing the right. You will still take an affidavit from him saying that on this transfer, your seniority will be at the bottom there.
My request, my lords, is that I'll take clear instructions, my lords. All matters may be disposed of together. Even if it is, my lords, during the course of the week, I'm all right. All of it may be taken up on board, my lords, and disposed
Want
together.
to adjourn it, then it goes on. When do you want? Tell us. How many days?
Lords, any day of my lord's convenience. Even my lords may have it on Friday.
We'll have it on Friday.
Oblige, my lords.
At the request of counsel and get those two also listed. I've a memo and get it listed those also. At the request of counsel for the appellant, petitioner, re-notify on Friday.
2/8.
Come on Friday.
Oblige, my lords. Great.
Thank you.
We take on record, the counsel for the respondent has filed 3 documents issued by the respondents, issued by the appellants. Just take this.
Thank you.
Lords, may I make a request? Lords, these two matters may also be connected because the other 3 matters have been connected, my lords. Exact same identical matter, my lords.
Do one thing. You will file a memo in this, mention it tomorrow.
I'll do so, my lords.
We will bring those also on that.
I'll do so, my lords. I'll do so. Deeply
Okay.
obliged, my lords.
That's how.
I'll do so, my lords.
And we list it on Friday, those 2 matters also.
Please, my lords.
Thank you.
Serial number 19.
Lords, in this matter, I appear for the petitioner. Lords, in the course of the day, my lords, I'll take steps.
Just 1 minute. But tell us, what is the ground for challenge? 49(3) doesn't say so.
Lords,
49(3).
Lords, here what has happened is, I'm not aggrieved, my lords. Lords, in fact, in this matter, rule is issued, my lords. The question of law, my lords, that involved here is, lords, whether the doctrine of parity can, my lords, be granted without, my lords, application of judicial mind.
When was the order passed?
Lords, the order was passed, my lords, in 2016. 16, my lords.
Where are we today?
Lords, in 24, my lords.
We'll leave the question of law open.
Lords,
That's what bothering you.
Lords, my request is
8 years, what is this?
Lords, the difficulty is this. Lords, what happens is parity has been granted to an assistant commissioner on an order, principal order, my lords, of an additional commissioner. My lords, service benefits, emoluments, my lords, are incident of service, my lords, and it is based, my lords, on the rank. If it is, my lords, blindly applied to all cadres, it would cause, my lords, grave financial burden on the union.
We are actually with you on that. The gentleman was only given a look after charge.
He was given a look after charge, my lords. And he says, my lords, for that for each additional charge that he held within the same office, my lords, he says that he must get additional pay.
Where is the order giving the charge?
My lords, the order giving the charge, my lords,
For 8 years, you were not, now just see this. Where is the order giving the charge? Now come to page 30, 45 or 13? Or 43, 42.
44 also, my lords.
42 first,
42, my lords, A1. Yes, my lords. Shri K. Girisha, Assistant Commissioner so-and-so Mysore, is directed to hold additional charge of Circle 1 until further orders.
And the tribunals relies upon that 49(3). Now this Calcutta bench they have relied upon.
Calcutta bench's order. That, my lords, we have complied with. That I'm not agreed, my lords, I've complied with that order.
Why, if you have complied with, why not parity?
My lords, the reason is this. We have complied with that order, my lords, for the simple reason that in the rank, my lords, of additional commissioner, it forms a separate office. Therefore, my lords, if one additional commissioner, my lords, of one region is given, my lords, charge of another region, then what happens, my lords, what transpires to be is that they simultaneously take care of two offices. It's, my lord, not an additional charge. My lords, illustratively, I may say this. Lords, it is this assistant commissioner holding Circle 1, Circle 2, Circle 3, my lords, is similar to, my lords, in a police station, there would be one inspector. There would probably be 2 or 3 sub-inspectors under him. One person may be on leave, the other person holds his charge.
That's one thing. Under 49(3) of the FRSR, that 49(3) is the fundamental rules.
Fundamental rule.
This should give us the fundamental.
I've appended, my lords, I've appended the rule to my petition.
Show us that.
Lords would find it at page 80, annexure E, my lords.
Page 80.
80, my lords. In page 80, annexure E of my petition.
See, then you should not give these kind of a charges. You should not give. Now, what transpired, it appears, what was his original designation? What was his
Assistant Commissioner, my lords,
assistant commissioner?
Circle 1.
Then you give him the charge of deputy commissioner?
No, my lords. What has happened here, my lords? My lords may kindly see. I have not given him a charge which is in his line of promotion, so on and so forth. In the same, my lords, Circle 1-1, Circle 1-2, Circle 1-3, my lords, are part of the same office. Therefore, my lords, if 1-2 is vacant, therefore there may be 3 assistant commissioners in the same circle under the same additional commissioner. They function, my lords, under the same office. This FR 49(3), my lords, applies when there are 2 separate offices itself. Here, what has happened, my lords, an order of parity is granted to an assistant commissioner, taking into consideration, my lords, an order principally granted, my lords, to an officer of the additional rank of additional commissioner, who, my lords, is a separate office. If, my lords, I was aggrieved by that order, I would have challenged it. I have not done so, my lords, I have complied with it. Because, my lords, that order on which parity is granted, my lords, would find it at annexure D. That, my lords, is under 49(3).
No, but you say 49(3) is not applicable.
I say 49(3) would not apply, my lords. I say, my lords, 49(2), my lords, and FR 11, my lords, which is annexure F at page 82, I say that would apply for this instant cadre.
No, you see 49(3).
May I read, my lords?
Yes.
It says, where a government servant is formally appointed to hold a charge of another post or posts which are not in the same office or which, though in the same office, are not in the same cadre line of promotion, he shall be allowed the pay of the higher post or higher post if he holds charge of more than 2 posts. In addition to 10% of the presumptive pay of the additional posts or posts, if the additional charge is held for a period exceeding 45 days but not exceeding 3 months, provided that if in any particular case it is considered necessary that the government servant should hold charge of another post or post for a period exceeding 3 months, the concurrence of the Department of Personnel and Training shall be obtained for the payment of additional pay beyond the period of 3 months. Here, my lords, what has happened is one, my lords, it must be either 2 different offices, or, my lords, he must be holding a higher post. Here, it is neither is the case. He holds, my lords, Assistant Commissioner Circle 1 in the same office, Circle 2, which is within the same office. Therefore, my lords, may kindly see fundament FR 49 subclause 2.
But here you say that he was holding the assistant commissioner.
Assistant Commissioner,
Different circle.
different circle, within the same office, my lords.
Which is or in the same universe, which in the same these are not in the same universe. So assistant commissioner is not in the line of promotion. It's a
Equivalent post in the same office. Therefore, my lords, it would not come within the ambit of 49.3. In the order, my lords, original order on which parity has been granted, they don't come also, my lords, in the line of promotion category. They come, my lords, in the separate office.
The
Calcutta order is, my lords,
Why did you implement it?
my lords,
Why did you implement
my lords,
it?
that was granted on another ground. That was granted on the ground, my lords, that it is a separate office. Because additional commissioner, my lords, under the rules is a separate office. Additional commissioner of one region.
Why do you come so late? 2016 order.
Lords, that the issue, my lords, is very, I'm given to understand my instructions while filing this were, my lords, that there was some undertaking given. Recently, my lords, in violation of that undertaking, contempt proceedings were initiated, my lords, by the respondent herein. Therefore, my lords, I am told that it was filed, and therefore, lords, I had to, in fact, on my legs, argue this matter at length. And in fact, my lords, I have an interim order.
Contempt filed.
Contempt is filed, my lords, in 1819, both the matters, therefore interim order, there was stay of proceedings, my lord.
Is it even appearing for them?
No, sir, notice has.
Now you have to serve them, na?
I'll do so, my lords. During the course of the day, my lords, by tomorrow, I'll do so.
Let the respondent is still unserved. Let fresh notice be issued for service on respondent. Respondent number, sole respondent.
Sole respondent.
So why don't you serve him?
I'll do so, my lords, during the course of the day.
When do you want?
Lords, any day of my lord's convenience.
They will give us after 2 weeks.
Obliged, my lords.
Sir, 21-8.
Lords, interim order, my lords.
Interim order to continue.
Grateful, my lords.
2021 Arjun. Twenty-two. Ramananda.
Lordship, in this case, I appear for the petitioner. Your Lordship, the petitioners are seeking interim relief as per the interim order of the Supreme Court. The government is taking time from 17/3/2023 to implement the interim order of the Supreme Court. Lordship may kindly take the order sheet on 17/3/2023. And same order is reiterated on 26/2024. In both the occasions, the government is just seeking time.
No. No, but what did you challenge before the learned single judge?
Your Lordship, the challenge before this learned single judge was regarding retirement age.
Now what is your age today?
My age is, I crossed 61. As on today, I crossed 61.
But did you had the interim order?
Before the learned single judge, I had the interim order. Then the interim order was vacated. Same situation before the Supreme Court. All had interim order, and in final judgment, it was vacated. So the Supreme Court directed the government to reinitiate the petitioner. The Lordship, kindly, I'll
But you
produce.
were not before the Supreme Court. You were not there before the Supreme
Yes.
Court. Yes, so this order would be only to the extent who were there before the Supreme Court. See the order. In the meanwhile, interim order which has been granted by the High Court to the benefit of the petitioners herein, but was ultimately vacated by the impugner, shall continue to inure to the benefit of the petitioner without the order order date 19 being given effect until further order. However, no person above 65 shall have the benefit.
Your Lordship, exactly the same thing. My application is also, I'm seeking the same relief.
Tell us one thing, you are not in service today?
No.
So have you challenged the decision that the retirement age must be 65?
Yes, Your Lordship. That is the appeal before this honorable court.
Very. Okay.
The appeal is, Your Lordship may kindly turn
Let's see what is the ground on which the learner single judge has rejected your prayer for 65 years. What happened to the petitions pending before the Supreme Court?
It is still pending as it is. In the meantime, there was the government of Haryana and Punjab withdraw the appeal. So the division bench of the judgment of the Punjab Haryana was confirmed. Based on that, the issue stand. Now there are series of groups of petition on the same ground, which is also constituted before a special bench is constituted. Since the matter is pending before the Supreme Court, I am only this honorable court on the last two occasions directed the government to consider the interim order of the Supreme Court.
See, interim order those are for the petitioners. Now interim order means you will be reinstated in service.
Yes.
But see the other side of it. If you succeed, you will get all the benefits. If the retirement age is held to be 65, you'll get all the benefits. Suppose you don't get the relief, you lose the appeal also.
Your Lordship, the exact scenario happened. Your Lordship, the exact scenario was before the learned single judge also. There was an interim order and we all continued our services for about a year. The learned single judge said that whatever the salary is to be paid, the exact situation was also before the issue was also before the Supreme Court. There also the judgment, by the judgment, all the petitioners lost the thing. And again, by the interim order of the Supreme Court, they are continuing. Now I am only relaying, Your Lordship, if Your Lordship kindly pass order whether I am entitled for the interim order of the Supreme Court or not. I cannot straight away go to Supreme Court because the appeal is pending. And this court has on the last two occasions directed the government to reinitiate, consider the Supreme Court. And
you have to satisfy us, even the appeal what you have filed, it has any merit.
Yes, Your Lordship. I will, because now Your Lordship has to look at the two previous order of this court. The court has clearly directed the government to consider. The government has failed to consider. Now, if Your Lordship wants to argue on the appeal, I am ready to argue. Your Lordship, Your Lordship may kindly, the interim order dated.
What are your instructions?
I am representing the UGC, my lords. I'm not the state.
Who is appearing for what are your instructions? What is no instruction? There was a direction given for you to take instructions. Who is the officer? We'll call the officer then here.
2 days time. 2 days. Connection matters are also pending. Your Lordship may kindly see the two interim orders of this court.
We will look into it. If you rely upon Supreme Court, we will say so. Supreme Court is not applicable to you. Let's be very clear. You have crossed that stage. The learned single judge has dismissed the appeal, writ petition on merits also. Today, the only issue is whether it should be 60 or 65.
Okay, your lordship issue, your lordship, my case is not exactly 62 or 65. The petitioners before this honorable court are seeking parity relief. There were professors working in universities. Those professors had 62 years as retired age, whereas the professors working in government colleges, they had 60 years age. So I initially start for parity relief that both they should have 62 years. So there cannot be disparity. Even that, the very initial stage, this court, learned single judge said why there is disparity. There cannot be disparity in retirement age between.
But the learned single judge has dismissed your petition. What was your prayer in the petition?
My prayer was only to, there were 4 groups of writ petitions filed before the learned single judge. Initially, my group of writ petition was segregated from the other group of writ petition, which had 65 years. They were all seeking for 65 years as retirement age, as per the UGC regulations. As per UGC regulations, all universities and colleges should have retirement age of 65 years. So the learned single judge, based on the earlier decisions of the Supreme Court, which during 2000,
You take instructions at the request of counsel for at the request of learned additional government advocate from a to take instructions, re-notify on. Just give it after 2 weeks.
your lordship kindly consider, because they're not getting pension, they're not getting anything.
He will decide the appeal. Let him take an instruction because the last order says so.
Even 17/3/23 also the order says the government should take.
Just see, as a last opportunity, you have to get your
Your
instruction,
lordship
otherwise
may
we'll call
give,
the officer here.
your lordship may kindly give the date.
828, sir.
You're giving it.
One submission, a similar batch as learned friend had already submitted. Similarly placed matter, similar batch, a special bench of this honorable court has only been constituted and it's.
When is that?
Your lordship, that I have separated from the bench and I have come because my case is different. This case was before the special bench. It was separated and it has come before this court.
It has detagged.
It has been detached. Now again, it cannot be gone into the same bench.
Take instructions.
22/8, sir, date.
22?
Lordship may seek for earlier date, your lordship, because
What is the date, man?
22.
We are giving in August.
No, from 1.5 years, they'll almost reach.
Okay, next.
Serial number 53, adjourned. 24.
My lord,
24, preliminary hearing. Shri Gautam Devulla.
my lord, I just seek for 1 week time, my lord.
For
because-
what?
My lord, only aspect is, in the writ petition, my lord, it has fairly been considered. It has stated that it has been considered that award is not passed and possession is not taken and land has lapsed, my lord. I just want to confirm that.
There is a conceded
Yes, yes.
by you also, by the.
My lord, I just want to
Also,
sometime, my lord, I'll just confirm that fact and inform the court next
What?
year about this exact position, my lord. My confusion is only with regard to, my lord. Notification is with regard to survey number 39/2 A, my lord. Petitioner claims notification is relating to survey number 39/2 A of Hulima village.
So this is 39/2 only.
Notification is with regard to
There is
39/2.
no confusion between 39/2 or 2A. This is that. This is only 39/2.
Yes, my lord. They mention it as that, but notification is only with regard to 39/2 A and page number 56 may kindly be seen. Yes, sir.
27 is very clear of the BDA Act.
Yes. Only with regard to whether that possession is taken or not. I'll just clarify and inform the court. My lord. I won't argue much on it.
No award has been passed.
Passed. That's what, my lord. Now,
Award has been passed.
my lord, my confusion is, he is saying in the writ petition, my lord, if the prayer is seen, my lord. Prayer is seen, he says, survey number 39-2, which is mentioned as 39-2A, my lord. But his mutation entry is with regard to 39-3B, my lord, 2B, my lord.
Which is mentioned as
So-
36-2A.
Yes, my lord, that is, but here, but we have only notified as 39-2A, 39-2B. His, this Kannan, my lord, his mutation entry is with regard to 39-2B, my lord. So I'm having some.
Now, okay, now which are the lands which have been acquired? 39-2,
2A and 2B, my lord.
not 39-2.
Not, here it's not mentioned here. 39-2 is not mentioned here, my lord.
See, it's your own case. If you see page 15,
Yes, my lord.
para 3,
Yes, my lord.
file statement of objection wherein respondent normally fairly consider that the award in respect of 39-2 measuring this was not passed.
Yes, my lord.
So
Only
you are also referring to 39-2.
39-2 award is not passed. It is not notified. No, I'm only getting this.
We'll have it after 2 days.
2 days.
That's your
I'll just
instruction.
seek
At the request of counsel for the appellant to re-notify and after 2 days to
18,
take instructions.
18, sir. Serial number 25. Shri Krishnamurthy.
Happy for appellant, my lords. In this case, my lords, respondent applied for the OTS scheme, my lords. Under the OTS scheme, he paid the entire amount, my lords. The loan account has been closed. Hence, I am filing a memo.
Or you have closed it.
Account is closed, my lords. Entire amount is paid.
That 6.5 lakhs he has paid.
No, not 6.5 lakh.
Huh.
Actually, that's what we are challenging, my lords. This honorable court directed to accept 6.5 lakhs with interest, my lords. That's what we challenged. The order of the DRT is finalized.
For a higher amount.
Yes, 33 lakh and odd, my lords.
He has paid that also.
He has paid 38 lakhs, my lords.
Oh, so now you are satisfied.
Yes, I am satisfied and loan account is closed.
Okay, so you withdraw this.
Yes.
Just show us this.
As a settled, my lords, it may be.
We will reproduce your memo. The learner counsel for the appellant has filed memo dated 29/7/2024 stating that the respondents have paid the entire amount. You just say this, stating as under. To stop in view of the contents of the memo, comma, the learner counsel for the appellant submits that the appeal be disposed of as settled.
Yes.
Noting the said submission and in view of the contents of the memo, the appeal is disposed of as settled.
Please.
Thank you.
Yeah. 26, Srimati Geeta Devi. My lord, this matter, my lord, seeking to challenge the order of the learned single judge, my lord, wherein the matter was disposed of on the ground that the issue is pending consideration before the Supreme Court. Lord, I would like to distinguish that matter is what is before the Supreme Court is the coverage of the construction workers. But what we are seeking to cover is the principal employer's establishment, which is the administrative wing of the office. In the administrative office, my lord, they have 43 employees when we went for inspection in the 2012. That is produced at Annexure D of their writ petition, which is at page number.
But tell us one thing,
Yes,
if the ultimately establishment is a construction company, will that not be covered under the notification?
My lord, in the very inception, my lord, every establishment employing more than 20 employees earlier, now from 2010 is 10 employees, they are liable to be covered under the ESI Act. My lord, therefore we sought to cover them. We did inspection and we called upon them to produce records. They did not produce records.
No, that's right.
At that stage, they came before the Honorable Court where the writ petition was premature and it could not have been disposed of, my lord. In the meanwhile, there was a clarification issue, my lord, regarding the construction workers. The establishment who are doing the industry which is carrying on construction work are liable to be covered. That's the principle. That is the administrative office, the sales department, marketing department.
They are not construction workers,
These are not construction workers.
but the organization is involved in construction activity.
Could be. They say it is. In that event, my lord, in fact, right from 1986 judgments of Supreme Court and our High Court says even construction employees are liable to be covered. But we had practical difficulties of identifying them because shifting mass of people.
That's right.
But what has happened now, my lord, with the AAA coming in, they can be identified, they can take treatment anywhere in all over India.
From one
So
one
therefore,
employer, other employer.
any other state also, they could take the benefits, and therefore, my lord, now that boundary, geographical boundary no longer comes in the way for benefits under the Act. Now, my lord, therefore, into earlier, my lord, we issued a instructions to them in 1999, we have practical difficulties to provide benefits to those construction workers engaged by you.
Yes, Mr. Sriranga, tell us one thing. See, you may be a construction company, but what is intended that circular is, those people who are in the unorganized sector. Today they are working at one construction site, they move to the other construction site. The difficulty was in those cases to identify it, if they want to withdraw it, if the amount has to be deposited in their accounts, how that has to be done. Then the EPF or this ESI possibly EPF has done it to my recollection. So they now decided that wherever the construction worker is working, he is working in Bangalore or in Madras or in Chennai, his identity would be, the person's identity can be established if he goes from Bangalore to Chennai, and that amount, whatever is deposited in that account can be accounted for. It was in that context possibly that was being said, those instructions which are under challenge before the Supreme Court. But not in a case, you tell us one thing. Is it your case, none of the employees working in this company are governed by ESI rules?
Lord, I don't have the minimum number of persons, Lord. Before 2011, it was 20. After that, Lord, it was reduced to 10.
10.
I don't have those numbers, Lord, which I have told them so. Lord, they wanted records of 2007. I said, I don't have it, but subsequent records I produced. Suo moto, Lord, what happens, Lord, is kindly, Lord, see the notification at page 118. This is the notification, Lord, instruction 4 of 1999, which precisely said, Lord, what fell from the Honorable Court to say that it's a disorganized sector. We have difficulties in identifying them. Therefore, we don't want to extend benefit so far as the disorganized sector is concerned. This is the notification. Now, my lord, it also says that subsequently notification will be issued. My lord, I was not getting any information from the department. Therefore, I applied under RTI. My lord, kindly see that application, my lord, which I applied under RTI. To that response, they give Annexure J, page 44, is dated 4th of March 2013, for which their answer was, there is no specific notification issued under 1(5) of ESI Act, extending, my lord, the benefit of or the sweep of the Act to the sector. This is their reply under RTI. Then, my lord, even in the objection statement, what was pointed out before the learned single judge, my lord, was their specific statement in the objections filed to the writ petition, which my lords would find at ink page 61.
We can't at least agree with you possibly that a construction company is not governed by ESIC.
Lord, if I don't have those numbers, my lord.
That's a different argument.
Yes.
You see the learner single judge proceeds, and that's your case, it appears also.
But that is what they have. They registered me prior to 15. All that I'm saying, my lord, is
kindly, my lord, see the statement at page, ink page 61, internal page 6 of their objection statement. Their specific case is to this industry, by a notification, it has been made applicable from 1/8/2015.
Okay.
That is their case. My lord, the notice that I challenged was prior to this date.
Well,
All
then,
that the
okay.
Honorable
What about-
Court, my lord, says is that this notification of 2015
But in
makes
any
it
case, Mr.
applicable.
Viranga, it could be applicable post 1/8/15.
True, my lord, but this registration is prior to that. Suo motu registration, kindly see, my lord, page 47. When I gave them the record and told them that I am not within the sweep of this because of these numbers, etc., they suo motu register me and assign me a number.
According to them, you don't supply anything. How would
I
they do
did.
it?
I did, my lord. I have produced records to show that I have provided details, Annexure G, page 41. Lord, they asked for some historical record, which I don't have. But I did, my lord, produce financials, etc., pertaining to from
But tell us
2011 onwards.
Tell us one thing, come to page 18.
Yes.
Needless to say, the second line, as and when the provisions of the act may applicable to construction industry, petitioner shall get himself registered. Let's be very clear, construction industry is covered by ESIC. What you are arguing is that because of the threshold of 10 workers should be there to get covered under the ESIC. The host, whether it is not a construction industry or not, is irrelevant. According to them, they are working in an administrative department. Unlike those unorganized people who are actually doing the construction activity at the site. We are concerned with those, minded. But now, insofar as this is concerned, construction industry being covered, and they are only concerning with the administrative department, then the ESI provision would be applicable.
Post 2015, my lord, according to them, it applies, but it is stayed by the Honorable Supreme Court, my lord, is that notification.
And you see I still recollect having dealt with this issue in Delhi. And it was actually those unorganized people where they wanted to give a card, all those facilities they wanted to give it. But at least to my understanding, construction industry not per se. Construction industry is covered and minded. You see the matter which is pending before the Supreme Court. It says Builder Association of India. Means all those builders who are in construction activity, they formed an association only with regard to those unorganized people.
Yes.
Or those people
Not
who
so.
are actually working at the site.
That's, my lord, two aspects, my lord, as to from when, my lord, they made it applicable is one, for which they say from 2015 particular date, 1/8, they made it applicable. Under RTI, they said that there is no separate notification. Subsequently, they have said that it applies. My lord, when they asked for documents, I said that the organized part of this, my lord, in my office, how many people were working, that's what they wanted to ascertain. That is, my lord, less than 20 is what I have told them. But, my lord, I was aggrieved by two things. They made a demand for previous period. They made a demand for the previous period prior to 2015, which has been, my lord, set at naught by the impugned order.
But this notification of 1/8/2015 is with regard to those unorganized sector. Not with regard to construction industry, which is otherwise covered. See, minded, there are two things. This cutoff of 1/8/15 is bringing in those people who are in the unorganized sector, covered under the ESI. So that would not be really applicable, this cutoff date. This cutoff date is only for those people. But insofar as these people are concerned, according to her, are people who are working in your administrative department, not people who are, involved in unorganized sector, who are only, involved in the construction activity. It is not such a case. So this cutoff in any case would not be applicable.
Lord, my submission, my lord, is when I have provided document to show that I don't fall within this framework, there is no, Lord, adjudication, nothing has happened.
Let's take it then.
Yes.
Two things. You are not covered under this cutoff date is 1/8/2015 is not applicable to these employees.
Yes.
These employees. There may be a coverage of construction industry per se. Now, the only issue is whether in that particular unit or establishment, there are 10 or more above people working. If yes, they get covered. Now tell us one thing, how do you say these people are working in the administrative department?
But your lordship, I may take your lordship's to annexure D at page 38, my lord. Page 38, my lords. With reference to the above subject, Social Security Officer visited your establishment in August and September of 2012. They are disputing coverage, stating that your company does not come under purview of the ESA Act, since you are a construction company and failed to produce record for verification of 2007. As per attendance for the month of April 2011, it is observed that you have engaged 43 employees and wages have been paid regularly. As per ESA Act, any establishment employing 10 or more persons for wages will come under the purview of 1(5) of the Act for the purpose of coverage. So 43 employees are there, my lord, and therefore on the basis of their own
This,
records.
in this company,
In this company. This is apart from not the construction workers who are engaged in
construction
building, no. On the administrative office.
where is this notification
Please, my lord.
with regard to these construction workers, where the cutoff date is 1/8/15?
May I take your lordships to two annexures, my lord, at page 118. With regards to the employees engaged in building. And
Yeah,
not
got
those.
it. We
Please,
want
my
to
lord.
see that. We
Yeah,
want to see that.
118, my lord, two annexures, I will take your lordships, my lord, under 118 and 123. My lord, this is the instructions dated 14th June 1999. Your lordships could find it, my lord.
Just see this, Mr. Sriranga, you will see.
In
para
page
two.
119,
Matter was examined at headquarters and it is informed that it has been the policy of the ESA not to cover the workers engaged in the construction
That's true.
agency belongs to unorganized sector due to the peculiar character of this. In the
That's
construction industry, the work is carried out through the construction worker at the construction site where projects are situated. The workers engaged in mobile and migratory in nature. The criteria and duration of the employment are vary from work to work. Due to the nature of employment, the nature of work involving construction workers, enforcement of ESI in respect of such workers and organizing medical. Now, this is 99.
please, my lord, such construction agencies who are employing 20 or more persons in their office and the office implemented areas are coverable under the scheme. However, it may be ensured that the criteria of 20
Next
or more
page.
persons.
Come to 123.
Point number 4, my lord, may I just read this, my lord? Only employees on the construction agencies who are posted in the office are to be taken into consideration coverage of the unit. So even in 1999, we made the distinction, my lord, they are coverable in
So
1999.
what they are saying is, they are not those construction workers. They are the employees who are working.
In the office.
Lord, I have denied it, Lord. My records don't bear this out. Except this annexure D, one statement which they make. I have produced record to show that I don't have more than those number of employees. And my lord, they when I make that statement, my lord, categorically in my correspondence with them, they assume to register me, my lord.
Let's take it.
Yes.
So the issue is on numbers.
Yes, my lord.
The issue is not whether it is a construction industry or not. That's a non-issue at all.
Not if they are taking the construction workers to be part of my numbers for the purpose of determining as to whether it is within the sweep of the act or no. Lord, then, my lord, that is how, my lord, they have proceeded. And therefore, I have pointed out, my lord, there is a notification of 4 of 99, which makes the issue clear. That is the stand that they take in
Show
response
one
to that.
averment in the petition of yours. Show one averment that the people who are get covered are the construction workers. Because 99 instruction presupposes construction workers.
Yes, my lord. Lord, para 2, my lord, I have specifically, my lord, said what is the applicability. And my lord, my specific case is, my lord, that in my office, I don't have these numbers. At page 6. I'm sorry, this is the appeal memo which reproduces. I'll show, my lord, from the writ petition itself. Writ petition, Lord, is at page 22. ground number 12.3 at page 27. Page 27, ink page 27, ground 12.3. That is my specific case. Respondent officers have visited the office of the petitioner. It is clear that from the inspection, that office of the petitioner does not employ 20 persons. That was a number at that point of time. Authorities have taken into reckoning construction site workers to also come to the conclusion that there are more than 20 persons working in the petitioner's office. That is what they have done. As a matter of fact, my lord, I did not have more than those numbers. At some point in time, my lord, this company was a big construction company. Today, my lord, they don't, they're not in big time construction business. There is a very skeletal staff that is available in this company. Because they took construction workers into reckoning, I, my lord, relied on instruction 4 of 1999 to say that you cannot do it.
Ma'am, this is your stand.
Please, my lord.
This is your stand.
Which,
If you see your stand also,
please, my lord. Your lordship is referring
page
to.
112,
Please, my lord.
you filed a review petition.
Yes.
Please, my lord.
Para 7. All employees, casual temporary workers are also liable to be covered under the, hence these workers working on the construction site are also liable to be covered from the beginning.
From the beginning, they're liable to be covered. Apex Court in South India Floor Mill has held they're liable to be covered. Our High Court in Escort's case also held liable to be covered. But we took a stand. Implementation was a problem, my lord. Because 1986, that Supreme Court judgments made very clear that they are liable to be covered. Shifting mass of people, unidentified people are also liable to be covered, is the Supreme Court judgment in 1986 South India Floor Mill. But my lord, we had problem in implementing it. Therefore, my lord, in 1999, we gave this clarification that for now, we are not extending the benefit for those who are engaged in construction activities. But those employees who are working in the office are liable to be covered. That also has.
Where do you say they are covered? They are working in office?
I've stated that in my objections also, my lord.
To us. And where is the impugned order where you have passed covering them?
Nothing.
Show us that.
This order has not yet been made. They have come very earlier. At time of implement, we have given them the, my lordship, I kindly say annexure K and Q is what they have challenged. When we sought them to giving them the, we have not passed an order under 45A order, nor has he paid any amount. Only the issuance of the annexure Q, may be kindly seen, well, what they have challenged, annexure K and Q. Annexure K is the giving them the code number, my lord, allotting a code number. And immediately they have come in a writ petition. So far as the numbers, my lord, it's a matter of fact that has to be established. 45A order we have to pass, or they have to challenge before the ESA court.
Where do you say these are the people working in the office?
We have said that, my lord, in my appeal memo, we have said that very
Show us
clearly. We
that.
said that, my lord. Not page number 7 of the appeal memo, my lord. Respondent establishment, paragraph 4, my lord.
Yes.
Respondent establishment registered partnership firm and is engaged in business related to construction industry. The said establishment was inspected by Social Security Officer in the month of August 2012. The corporation was called upon the establishment to cover under the ES Act, but the respondent disputed his company being covered under the ES Act and did not produce record from 2009. But they produced attendance of age register for the month of April 2011, wherein it was found that the respondent had engaged more than 43 persons at the establishment month of 2011. The corporation had indicated in this correspondence dated so-and-so at annexure D that as per the observation Social Security during the inspection, the attendance register was month so-and-so revealed were engaged in wages paid regularly to these employees. Therefore, the respondents called upon to contribution to register the establishment and comply with the provisions. In fact, the appellant corporation also sought for records of so-and-so and they had not produced it. The corporation was therefore constrained to initiate proceedings under 45A of the ES Act issued the notice 18/9/2013, which is show cause why amount so-and-so should not be determined. Respondent sent a reply to the notice reiterating it is not liable to be covered, but did not participate in personal hearing. Respondent given opportunity to produce necessary records. If the establishment had less than 10 employees in the administrative office, the issue of coverage does not arise. But if more than 10 employees were employed in establishment, then it is liable to be covered independently of the workers engaged of the auto work on the construction sites. We were very clear, my lord, which we are trying to state, my lord. Before this issue could be determined, the respondent petitioner approached this honorable court by filing writ petition in WP.
Then, Mr. Sriranga, the only issue is this. Whether they are construction workers or not, whether they are part of the main establishment. What is being said, if you see page 38, they say they are the people who are being paid, who are being paid regularly. In a way, they want to show that, or they are saying that they are the, people who are permanent in nature. Not like, unlike a construction worker who is on the construction site, construction is over, he moves on. That is not the case, that's what. We can do one thing. We can now send it back to you. You have to pass a final order.
45A order has to be passed, my lord.
You can give a hearing to them.
Very
Hearing and then pass an order. This will be clarified. You will clarify, every will clarify. But one thing we will say, so this is, the issue would be, is it your case? They are construction workers?
Yes, ma'am.
Very good. That they are.
I have specifically said that.
It
they
is
have
not their case. So that will be heard and he will decide.
very good.
And also the number.
Numbers.
The number.
Lord, I have been called upon, my lord, to register. I gave a response. Now, my lord, when I gave that response, what they do, my lord, is they sumo to register me and give me ID. My lord, I was aggrieved by that also, because the statute says that this is the situation. And I, my lord, when they called, they did visit my place. And then, my lord, they said that you have to compulsorily register. So I gave them a response specifically to say that I'm not covered by this because of these reasons. Lord, they give me let them also consider, my lord, as to whether I should be compulsorily registered, because this is a sumo to registration at page 47.
No, what can be a ground that you should not be registered?
Lord,
if you are not a construction worker.
Lord,
if they are not construction worker, then necessarily registrable.
Yes, that's correct, my lord. But that is, before that issue could be gone into, my lord, Form 1 is issued. I've been registered on their own. My lord, on their own, they took the step, my lord, to register me, give me a password, code, etc.
Ma'am, tell us one thing. What is the effect of now you have covered this?
We have allotted a code number asking him to cover. He only has to utilize that code number and cover. In the event they do not get coverable by virtue of not having the numbers, that code number will not have any effect, my lord.
Why should there be a code?
Will not have any effect. They will, see, the question is that according to our documents, they are 43. Because our inspectors observed and seen this, it's not, we have taken the figures in the air. Now, my lord, if there is an adjudication before the authorities and they are able to establish, we don't have that many numbers, then that is put a quietus to the dispute between the two parties. There is no need for them
We
to.
will record it that, Mr. Sriranga, we will record her submission.
Lord,
Allotting a code number does not make them compulsory.
why should
have to
they
pay.
register? No, that it's not just allotment. It says establishment has been registered under ESI Act. Consequence of that is I have a code, I have a registration number, etc.
Can we say this?
Please,
If,
my lord.
assuming for a moment they don't get covered in law,
That aspect also the officers can consider it.
if not covered, whether the code which has been issued to them need to be continued.
They have to deregister me, my lord, if I'm not within the.
Obviously, once they pass an order that you are not covered, the consequence must flow.
Or, my lord, let them take a decision on the numbers and applicability, and then, my lord, as of now, this is quashed.
What they are trying to
But
say is that in future they are liable to cover from 2011. They are ready to be covered, but not earlier. That is their contention.
So they say not before 1815.
15.
My lord, even prior to 1815, the stand is there. The code number, my lord, code number may not change, but the date on which they have to pay will be decided by the authorities, my lord.
But what we have said, 1815 is only with regard to construction workers.
Those on the sites.
But in any case, now the issue of 45 or 10 or whether they are construction workers or not need to be gone into.
Please, my lord.
So then
If it is construction workers, by virtue of Supreme Court order, we may not be able to compel to payment,
That's-
but or to pay or even coverage. But if it is other than that, if there are numbers 10, they are liable to be covered.
Whatever is the position of law,
Will follow, my lord.
that's all.
Please, will.
And then, but then accordingly, insofar as his grievance is concerned,
Lord,
on the code.
may I make this submission, Lord? They agree, Lord, that the applicability to the construction worker, etc., Lord, starts from 2015, the coverage. They had made an inspection earlier, historically, Lord, 2012 or something. After that, Lord, the process has started. Let them visit now, verify, and Lord, then take a Lord, decision.
They have a material before them.
I have produced. That's the material that I gave.
My lord.
They will give you a hearing
Hearing will be the, let him
and
produce the
they
records.
will take a final call, whether 45 or less than 10, or yeah, more than 10 or less than 10,
Yes,
whether construction workers or not.
yes.
Okay.
Pursuant to that, Lord, they can either ask
Then
me to
further action
register
will be taken.
or, pardon me, Lord. Pursuant to that, Lord, they may, this registration has been quashed. Lord, let them take, I will appear in the hearing, give them whatever material is needed, place my submission. Based on that, Lord, let them, that is the situation today also. Nothing prevents them even for today to do that.
Cannot be
We
quashed at
challenge-
this stage, my lord, because at this stage, they,
It's already.
please, my lord.
Yes, one. This appeal has been filed by the ESIC Corporation and its functionaries challenging the order of the learned single judge dated 13th March 2019, whereby the learned single judge, on the ground that the respondent is involved, is in construction industry, comma, the provisions of the ESIC Act shall not be applicable till such time the matter is decided by the Supreme Court in Builders Association of India versus the Employees State Insurance Corporation, SLP 1335951 of 2018. And if the provisions are made applicable to construction industry, the respondent shall get itself registered under the said provisions. Full stop. The next para.
Admission is recorded. Admission is recorded in para 6.
That is incorrect, my lord, because our objections have to be read even para 8.
That was sought to be, Lord, it's there in the objection statement.
Yep,
Right,
objection.
but this admission, admittedly, the provisions of the act made a construction industry.
That's there in the objections also.
No, my lord.
1 minute. If you see 99, that issued on 99, which is
118 page, 118, my lord.
108.
That has been clarified in para 8 and 9. The learned single judge has just read 12 and 13 without reading my para 10, 9, 8,
It's
9,
not
10.
construction industry.
Workers.
These are construction workers. So the whole issue arose for them only. So it's not construction in the construction industry per se, I think it's covered also.
Covered, my lord. My lord, your lordship may kindly permit me to read paragraph 8, 9, 10 of my statement of objections, page number 59, which the learned single judge has focused only on para 12 and 13.
Full stop. It's all right. The suffice to state that the issue whether construction workers shall be covered under the provisions of the ESIC Act is an issue pending before the Supreme Court in the aforesaid SLP. So the submission of learned counsel for the appellant is that yes, the appellants have covered the respondent on the premise that the respondent has engaged regular employees, 43 regular employees in its administrative office in the month of April 2011. So according to her, despite several notices, the respondent did not cover its employees and sought time to do the needful only prospectively. So according to her, the 43 employees are not those employees who are working as construction workers. And hence the respondent cannot escape the liability of covering these 43 employees under the provisions of the ESIC Act. According to the learned counsel, the learned single judge has erred in concluding that every construction industry, that the respondent being a construction industry as such is not covered in view of the pendency of the SLP before the Supreme Court. In other words, it is her submission that in view of the it is her submission that the intent of the appellants is to cover the persons working in the administrative department, such a conclusion need to be set aside. So we have heard the learned counsel for the appellant and Mr. Sriranga, learned senior counsel for the respondent for some time. Full stop. It is agreed by the counsel for the party. Full stop. Mr. Sriranga during his submission has also stated that even otherwise it is the case of the respondent that only less than 10 employees are working in the respondent office. And as such, in terms of the provisions of the ESIC Act, which is applicable to an establishment having more than 10 employees, the said provisions of the Act cannot be made applicable to the respondent. Full stop. Since the issue now which arises for consideration is whether the coverage is only with regard to only because of the employees working in the administrative department and not the construction workers, and also the fact that whether less than 10 employees or more than 10 employees are working in the respondent organization, we deem it appropriate to set aside the order of the learned single judge and remand the matter back to who is the authority, ma'am?
The ESI corporation, my lord,
Who would be does he act under a particular provision?
and a person, I mean, it will be an authorized officer in that unit, my lord,
Demand back to the appellants.
appellant number 1 and 2, deputy director, my lord, who passes the order, my lord, 1 and 2.
Back to the appellants. Appellant for a reconsideration of the case by the competent authority who decides the issue of coverage, who shall hear both the parties on the basis of the material already on record, and take a decision as to whether the employees who are sought to be covered by the appellants are working in the administrative department and not connected with are not construction workers. Also the fact whether in fact less than or more than 10 employees are working in the respondent organization. The aforesaid exercise shall be completed within a period of
Let them appear on date, my lord, after that within two months.
within a period of 4 weeks.
After the, let date for appearance for them, my lord.
Within a period of 4 weeks, effective from the date of first appearance of the respondent before the authority concerned. Full stop. The authority concerned shall notify the date and time of hearing to the respondent after the receipt of the certified copy of this order.
But let them appear, my lord, otherwise even receiving notice, there will be a problem, my lord.
Why?
A date may be
That has never
specified for
been the
parties
case
to
that,
appear, my lord.
All
Let them
cases have been
appear.
received by me. I have even responded. I don't know why she is making that statement.
You will receive this, he will notify the date and time, they will appear on that day.
Yes. Lord,
And then within thereafter 4 weeks, you will decide the issue.
Lord, they have said up to 16/3/11, it was 20 employees. Thereafter, it is 10. That is what they say, my lord. That's the examination that they wanted to do.
You are right, Mr. Ranga. What evidence they have, we don't know.
No, correct. No, but because my lord has said 10, they will sit on that number 10, my lord,
Act says
because-
10 from 2010.
because there is a, up to 16.3.11, number of employees minimum was 20. That is what they say in Annex A. It is their letter.
Then we
2012.
can say this, all pleas of the, all submissions of the council for the parties, of the
Yes, sir.
parties are left open to be decided by the competent authority. Work
But may I make this request, my lord, instead of saying, my lord, that the single judge's order is set aside, if my lord could say it is modified with this direction, then my lord,
No, Mr. See, the learner single judge order goes on that construction industry, that SLP.
that is also recorded, my lord. That was, he records my statement that there is an SLP pending. That, that order, my lord, records that that was my statement. Then, my lord, records their plea and finds that there is no, lord, they have not objected to that aspect. And also, he records, my lord, what is there in the objection statement. Therefore, my lord, if they have to do a factual verification now, let them do the factual verification. If I have to
We will
register, I
say-
will do it.
We will say modify.
Yes.
We'll say, why say, we say. Let's assume for a moment, they can, if they are able to establish they are construction workers. Let's assume hypothetically. Then then possibly what has been held by the learner single judge based on that Supreme Court judgment, it would be right. If
Yes.
construction workers, then they would be covered by the SLP pending before the Supreme. But if it is not, you're getting the point, ma'am?
Please,
If
my
it
lord.
is not, then that will not be applicable to them.
That will not be applicable, my lord. Now the learned single judge, my lord, has quashed the communication of giving them the code number. That is what they are trying to say that
they
cannot be
could
done,
not
my
have
lord.
given.
Now,
Let them do the factual
the
verification. I will
act-
register if it is
sir, the
necessary.
act
I have to
specifies
register.
they have to do it. When they don't do it, we have done. That cannot, now what they are trying to do, they're postponing the date by this order because it's quashed. They're saying later on it will be postponed.
Ma'am, simple. If they are not construction workers, the
If
date
they do
would.
not have 10 employees, that will not be there.
That's right. The date will go back, whichever is your date of coverage.
Please, my lord, that's all.
But they are construction employees, then the
It will be-
Supreme Court matter would.
We'll have to await the Supreme. That we are clear, my lord. That we are clear.
Then we will only say modify it.
Very well, my lord.
That otherwise if we set aside, then possibly then it may not be clear. We will say
Yes.
modify.
Grateful.
All contentions left open on both
All
parties.
contention left open. Whatever you want to argue, you will argue it.
Very well. my lord.
Thank you.
Obliged.
Shri Narasimha Swami. 27. Serial number 27,
Just pass over, man.
28 Adjournment, 29. Shri Vikram Rajgopal.
The appellant. The respondent. What had happened was the respondent was unauthorizedly absent for more than 2 years, and therefore the appellants dismissed him from service. And the appellate authority also confirmed the order of dismissal. The writ petition was filed challenging the dismissal and the order of the appellate authority. And the learned single judge has, in essence, remanded the matter to the disciplinary authority. But if I may just point out a few facts, what had happened was, if your lordships may kindly take page 121.
But how can be agreed by this order now? The matter goes to the disciplinary authority.
If I may just point out a few facts, what had happened was, we issued notices to the respondent. He did not appear and he did not report for duty. Thereafter, in fact, we even took out paper publication. And as per our rules, there's a special procedure under Regulation 14, which says that if he is absconding or if it is impracticable to serve notice, then the authority can proceed and to dismiss him. His main grievance before the learned single judge was that there was no inquiry that was conducted. My respectful submission is that an inquiry was not required at all. Because
very well, which is the judgment you are relying upon?
I am relying mainly on Chennai Metropolitan Water Supply versus Murli Babu.
What does it say?
This is on unauthorized absence, but if I may just point out.
There is judgment also. Just let's ask him first. Where were you for 2 years?
Lord, he was had a serious ill health.
Where is the one communication show us that you informed them?
Lord, what has happened, my lord, he had sent his, the family member, his wife, to inform the authority. They were orally informed about his ill health.
Which authority? Who is the
The
officer?
third respondent, authority, my lord, who was the, under whom the respondent was working.
Okay,
He had informed about ill health.
where do you say so?
This is, in my writ petition, my lord, I have kindly taken.
For 2 years, did you send your leave applications?
Not that the specific stand of the respondent is that he had intimated the respondent authorities about his ill health and to.
Show us one letter where you have sent your medical papers.
Not, he had reported for duty after the dismissal order was passed, along with medical reports.
See, this is something surprising. You are absent for 2 years, you will not even send a leave letter, you will not send your medical prescriptions,
Not
but
what
you
has
have
happened, my
informed
lord.
him.
Orally, my lord, he had informed because there is no.
We
my lord-
can't take it.
No, your lordship, I kindly appreciate. Here is a case where, my lord, the dismissal order has been passed bypassing the procedures. That is
Pardon?
bypassing the procedures inscribed under the regulations. The regulation of the respondent clearly mandates that no employee should be dismissed without following without holding any inquiry. Kindly see, my lord, regulation number 9, where under which, my lord, the appellant has passed the order.
What about 14?
14 also says, kindly see, my lord, the 14 also specify the circumstances under which order dismissal has to be passed. They should record the reasons why the inquiry is, my lord, not necessary. There is no the reasons in the dismissal order. They have not recorded any reasons why the inquiry is bypassed or why the inquiry is not
But
necessary.
tell us, in view of 14, why inquiry is required?
My lord, kindly see, my lord, I may be permitted to read 14, my lord, the special procedure.
Which page?
Lord, it's my lord, my friend, my lord has extracted the, my lord, the provision.
Yes.
This is at page 161, your lordship.
That is regulation 14, my lord, subclass 2, where the officer concerned has absconded or where the officer concerned does not take part in the inquiry or where for any reasons to be recorded in writing, it is impracticable to communicate with him or where the disciplinary authority for reasons to be recorded in writing is satisfied that it is not reasonably practicable to follow the procedures prescribed in this regulation. No reasons have been assigned why, my lord, they have not held the inquiry. No charge sheet has been, charges have not been framed.
No, here the charge sheet is not contemplated in this provision.
My lord, the procedure requires, I should be, my lord, issued with a charge sheet.
Not necessary in view of this provision.
This, my lord, this, they have clear rates where I am not reachable, not communicatable. If that is the case, then they are justified in passing the order. I am very much, I have received the call notice. I have sent in the intimation.
But they will make communication, but you will not communicate to them.
Not is the ordinary class D employee, my lord, you will not see.
That's no ground, please. That's
He
no
was
ground.
under treatment for about the 400 days in it was a serious liver disease was there. He was also suffering from the hepatitis. And the person was seriously ill health, my lord, was taking treatment in the hospital. And is a group D employee, my lord, was not aware of the total procedures. And the lenient will could have been taken. My lord, I have relied on the judgment of this honorable court in the very identical situation involving the respondent.
Sure.
Recorded, my lord, in my paras 19 of my writ petition. Paragraph 19 of my writ petition, my lord, page number 37, paragraph 19. I will pass on the judgment.
Page 97.
Yes, ma'am. Page, my lord, 37, my lord. Page number 37. The appellant corporation, my lord, is there, and the regulations 9 has been dealt with by this honorable court by referring to various Supreme Court judgments. There is a clear recording by this honorable court saying that irrespective of the, my lord, the alleged charge, the permanent employee cannot be dismissed without following the procedures. Kindly, my lord, I may be permitted to read one paragraph in this judgment, my lord. The very regulation of the appellant corporation, my lord, was under the consideration by the Sambo court in the said.
Where is reference to regulation 14?
Yes, my lord. Regulation 14, my lord, there is no reference, only regulation 9, which deals with the dismissal. Regulation 9, my lord, it mandates that before passing an order of dismissal, an opportunity has to be given by holding an inquiry.
That we know.
Yes,
The
my lord.
basic principles. But where is the position when there is a regulation like 14?
Lord, the 14
Now you have
also-
to see what is the interplay between 14 and 9.
True, my lord. 14 also, my lord, does not, my lord, empower the corporation to impose the penalty without affording an opportunity of hearing.
Where does 14 say so?
Yes, my lord. That's what, my lord, 14 I have read out to lordship.
No, 14, in fact, the Supreme Court has interpreted this provision, a akin provision.
Lord.
See 162 once again.
Lord, I may be permitted to read, 14A. Special procedures in certain cases. The following provisions shall notwithstanding anything contained in the regulations 10 to 11. Lordship may kindly appreciate this. 10 to 11, my lord, that there is the one which deals with the punishments. Whereas, my lord, that the dismissal comes under regulation 9.
Yeah, just read it.
Yes, sir.
Notwithstanding now 14. Notwithstanding anything contained in regulation 11, 12, 13.
11, 13.
14 is this.
Yes, sir.
Okay, now see 11.
Yes.
You have 148.
Yes,
Come
my
to
lord. Yes.
140. 11 is procedure for imposing major penalties.
Yes.
Okay,
The procedure, the
Then-
impose this major punishment.
then
Yes.
that's major penalty.
Yes.
Okay. 12E and 11A is action on the inquiry report. 12 is procedure for minor penalties.
Yes.
Okay.
Yes.
12A is communication of the orders. 14 and 13 is joint inquiry. 14 says, notwithstanding whatever is stated in 11 and 12. 14 is an exception to 11 and 12.
Yes.
For 14, in these eventualities, an action can be taken. The rigors of 11 and 12 would not be applicable. It will not be applicable 11 and 12. If a
Otherwise-
case falls within 14.
Lord. Otherwise, my lord, the very purpose of, my lord, the regulation, the 9 will become redundant. For this reason, my lord. Regulation 9 clearly
Let's see
states
regulation 9.
how
Let's see.
the punishments should be imposed on an employee. It's regarding, my lord, imposition of
C9.
5, my lord, is the major penalties, 9(5).
That's right.
Yes.
So 11 and 12, which are major and minor penalties, they would not be applicable when if the case falls under 14.
If that is the case, my lord, every employee can be, my lord, dismissed by invoking 14.
Provided,
Yes.
provided the case falls within 14
Yes.
and there is a reasons to be recorded in writing.
Yes, there is no reasons are recorded. Kindly
That's a
see.
different argument.
Hmm.
If you are arguing,
Yes.
yes, there are no reasons recorded, we will ask them to
Yes.
show us the reasons.
If that is the, my lord, the reasons are to be recorded, why inquiry is not necessary in the instant case. There is no reasons. And that can be done only, my lord, when the employee is not accessible or when he is absconding. Such the special powers can be invoked. But in the instant case, my lord, the respondent is, my lord, had very much received the notice. He had orally communicated to the notice and he had immediately approached the respondent authorities, the appellant authority, sorry. So when that being the case, my lord, 14, the two cannot be invoked at all.
You're right. We will see that what were the eventualities that they have invoked 14.
Yes.
Whether there are no eventualities existing, 14, if they have invoked, then we must set aside. Or we must agree with the learned single judge.
And furthermore, my lord, I may be permitted to make one more submission. What all that, my lord, the learned single judge has done, set aside the order, remitted the matter back to the authorities to follow the procedure and to pass fresh order. No hardship could be caused to the other side.
But
Then-
suppose tell us, if case falls under 14, why should the matter be remanded back?
Even 14 also, my lord, my humble submission is does not, my lord, empower the authorities to impose the arbitrary punishment of dismissal, bypassing all the procedures.
That because of 14, now let's see the reasoning given by him.
Yes, my lord. The lordship may kindly see annexure D, the order of dismissal passed by the third respondent.
Now,
Page
just
number-
before that, let's have their the appeal. Now come to page 10 and 11 of the appeal.
Yes.
Para 7,
Yes.
they refer to regulation 9. Okay. Then regulation 11 prescribes the procedure for imposing major penalty. Regulation 14, which prescribes special procedure in certain cases, is extracted below with immediate. Now, come to next page. The respondent did not respond to call notices dated this, as well as final notice dated this, taken out by the waiver of paper notification. The respondent was therefore absconding and it was impracticable to communicate with him. In these circumstances, appellant number 3 passed an order dated this, dismissing the respondent in terms of this. In the dismissal order, it was noted the respondent was unauthorized absent from 18 to 2020, 783 days, and he did not respond to call notice. It would be pertinent to note KPTCL White Circular has adopted the government circular dated this, the government. Where the employer unauthorized absent for more than 4 months, the punishment shall be dismissal. This is the reasoning given.
No, the reasoning is given in the appeal, not in the impugned order. Kindly see, my lord, the impugned order at page number, my lord, 53. Annexure D.
53.
Annexure D, my lord, is in Kannada. 55, my lord, is the translated copy. May be permitted to read. Manjunath Government also, divisions also. For a period of about 783 days without obtaining the leave from the higher officers and not giving information and obtaining the sanction of the leave, have remained unauthorized absent from work. And this shows that the negligence towards the serving the company, and in this connection, under reference 1, letter show cause notice was sent to the address mentioned in the service register through the register post acknowledgement, and the same is received by the said employee. Further, from this office under reference number 2 letter, the said employee was issued a final call notice to attend the work within 7 days, and also the paper publication was given on 13/6/2012.
That should be 2020, man. My apologies. On the last, the date on page 56.
It has been
Should be
wrongly-
13/6/2020, not 2012.
Prabha and Deccan Herald newspaper calling to attend to the work, and if failed to attend the work without any notice, will be dismissed from Bescom service, and the said employee within the said days has not reported for the works. And when all the above matters are examined, where Manjunath found unauthorized absent and showing the negligence to company work, the company's day-to-day work is being hampered. And as he is not interested to continue to work in the Bescom, and the prima facie is seen that he is remained unauthorized absent from attending to work. And hence under CDCA 1987 regulation 14, as per KPTCL CDCA rule 28 and rule 9(8) and circular numbers also, by imposing the serious punishment of the following final order is passed. Also, executive engineers also division and discipline authority do herein the Manjunath foreman is dismissed from company services. He is not eligible for any service benefits. The same should be mentioned in services. So, my lord, here the authority says that notices have been received, is very much available. There is no absconding from the, my lord, absconding, or is not inaccessible.
Did you receive those notices?
2 notices have been received, my lord.
You received it?
One in the newspaper, the other, my lord, as the call notice was received. Call notice was issued to report for duty. So he did not, the report because of, he was recovering. He had sent a word to the respondent authority, appellant authority, which was, my lord, the considered. And in spite of that, my lord, the impugned order has been passed. And as I read, my lord, no reasons have been assigned. Why,
All
my
right,
lord,
what
the
else you want? Here,
why the inquiry is not contemplated, why the inquiry is not initiated in this issue, my lord, is not recorded. The reasons have to be recorded, why inquiry is bypassed, why inquiry is to be.
but they have said this.
They have-
Two notices, one paper notification. You also say you have received it. Still you have not reported back.
Notice, my lord, has been received. That is not disputed. The paper publication was issued within 15 days, my lord, he was dismissed from service. No, my lord, here is a case wherein, my lord, he has, my lord, worked from 99 till 2018. Without, my lord,
We are surprised.
Yes.
The blame is being put on them that they should give you and invite you to please come and join.
True,
Who
my
will
lord.
not join?
There may be, my lord, some lapses on the part of the respondent. I am not disputing. Lord, here, your lordship may kindly appreciate he is a Group D employee who has been observed as a gangman. Based on his 7th qualification, my lord, he has been appointed. He is not a, my lord, legally, my lord, the well-known person. He was under severe ill health, taking under treatment for about 2 years.
Maybe in difficulty. The only thing is, it's required. Look here, and we are not saying we should be so harsh also.
Yes.
See, ultimately it's employment, ultimately a Group D employee. One thing which really required to be done by him is, look here, these are my medical prescription, this is my medical condition, I am unable to join. And surely no employer would be so harsh on you, knowing well that this gentleman is unable to join because of his sufferings. But for 2 years, no communication, that we are unable to accept it.
I'm not disputing your lordship's the opinion, Lord. By my submission is, there are other alternative the punishments which could have been, my lord, imposed on the respondent workman. Imposing the very harsh punishment of dismissal, my lord, at this age, my lord, where he is still, my lord, 48 years. Without, my lord, entirely, my lord, forcing the entire family into the streets. He is, my lord, not gainfully employed, and that the absence is not intentional and deliberate. Your lordship may kindly appreciate. Supreme Court also says, if the absence is intentional and deliberate, then they
But
will.
for 2 years, will it not depict intentional?
Kindly see, my lord, the medical certificates.
So 2018, 32, 2018, what is this like in any notice?
I don't think we should in these facts.
Lord,
The appellate authority order is quite a reasoned one.
Appellate authority, my lord, had looked into, my lord, the alleged default cases. Kindly appreciate, my lord, without even, my lord, issuing any notice. The alleged, by relying on the alleged default cases, my lord, wherein, my lord, several cases he has been, my lord, the leave was sanctioned. So they still, my lord, by relying on the old cases, my lord, the order has been upheld by the appellate authority, which is, my lord, does not, my lord, they stand to the scrutiny of law.
Not in these.
Lenient view should have been taken, my lord, is my humble submission. Though, my lord, there is lapse on the part of the respondent. They could have, my lord, imposed the alternative punishments are there in the regulations.
Just say this, we have heard the learned counsel for the parties. Full stop. The challenge in this appeal is to an order dated 16 June 2023, passed by the learned single judge in writ petition 12473 of 2021, whereby the learned single judge has allowed the writ petition filed by the respondent herein by stating in paragraph stating as under. Just see page 25 under the heading order. Some of the relevant facts that need to be noted in this petition are the respondent herein was appointed as a gangman with the appellant in the month of February 1999. Full stop. He was absorbed as probationary mazdoor in the year 2009. Full stop. Subsequently, he was promoted as junior powerman in the year 2011. Full stop. The conceded case is that the respondent remained unauthorizedly absent from work for more than 2 years, that is from 16/4/2018 till 7/8/2020. Full stop. It is the case of the appellant that the respondent had neither informed the subdivision office nor the division office of BESCOM regarding his absence. Full stop. It is also, next para, it is also their case that notices were issued to the respondent on 11/10/2018, 21/12/2018 regarding his unauthorized absence from work and calling upon him to report to work. Full stop. It is their case that the respondent, despite notices, failed to reply to the same. Full stop. Finally, a final notice dated 3/6/2020 was issued to the respondent in Kannada Prabha and Deccan Herald newspapers on 13/6/2020, calling upon the respondent to report to work within 7 days, failing which he would be dismissed. However, even after newspaper publication of the final notice, the respondent did not report to work. Full stop. The submission of the learned counsel for the appellant is that the learned single judge had erred in holding that the respondents, that the appellants, while taking the final action against the respondent, were required to hold a departmental inquiry in accordance with law. Full stop. In accordance with law. Full stop. Departmental inquiry in accordance with law, which is clearly erroneous. The learned counsel for the appellant, in support of his submission, has drawn our attention to Regulation 14 of the regulations framed by the appellants, which reads as under. Page 161, 162.
Lord, that the provision, my lord, is applicable only to Lokayukta cases, my lord, where the employees are involved in Lokayukta cases, or where special the commission has the investigating into the matter. Only to those cases, my lord, these provisions have been incorporated. And this is the-
According to him, Regulation 14 is exception to Regulation 11, 12, and 13, which are the regulations which provides procedure to be followed while imposing major penalty, minor penalties, major penalties, minor penalties, or joint inquiry. Full stop. In that sense, the rigors of holding a departmental inquiry for any misconduct as directed by the learned single judge is not applicable, are not applicable. Full stop. In support of his submission, he also states that the communication of dismissing the appellant from service taken by the appellants is a very reasoned order. In support of this, he has drawn our attention to pages 56 and 57 of the paper book. We deem it appropriate to reproduce the said. No. What is this order?
This is the order of dismissal dated
This is
7th.
the order of the dismissal, na?
Indeed.
56, 57, 58, which we reproduce as under. It is also his submission that against the order of the dismissal, the respondent had filed an appeal before the appellate authority, who had also passed a reasoned order on
30th April 2021.
15 on 34/2021. The English translation of which has been annexed at pages 92 . To 109.
109.
109. He also highlights the fact that the appellate authority has also noted the past absence period, unauthorized absence period. He's just say his leave details. His leave details which includes his unauthorized absence on different occasions. He also states that the appellate authority was of the opinion that was of the opinion that the treatment undertaken by the respondent undertaken by the appellant, by the respondent, did not prescribe any medicine. Medicine, and with an observation, no follow-up is recorded. No follow-up is recorded. In that sense, the respondent could not able to prove that he was suffering from serious nature of diseases and obtaining the treatment as an inpatient. Full stop. He further states that the plea of the conclusion drawn by the learned single judge, if he's accepted, then the regulation 14 will become otiose. And in every case where, even in a case of unauthorized absence, the appellants cannot invoke the regulation 14. Full stop. On the other hand, the learned counsel for the respondent would justify the order passed by the learned single judge in as much as it is basic principles of natural justice that a person cannot be dismissed without following the due process of law. In this regard, he heavily relies upon regulation 9 of the regulation which contemplate
Dismiss.
There is 9.
That's at page 140.
Which contemplate the nature of penalties. That is major/minor penalties. Full stop. Major and minor penalties to state major and minor penalties. Full stop. He also states that he do state that the respondent did convey to the officer, his supervisory officer, about his illness, and he is unable to attend the office. Full stop. That apart, it is also his submission that the respondent, being a Group D employees, a compassionate view need to be taken. Full stop. Having heard the learned counsel for the parties, we are of the view that the learned single judge has erred in coming to the conclusion in the impugned order that a departmental inquiry should be held against the respondent before any action is taken. This we say so for the reason that regulation 14, on which a reliance has been placed by the learned counsel for the appellants, is an exception to a departmental inquiry. Departmental inquiry under regulation 9, 11, 12, /13. /13. It is the appellant's case, and also noted from the impugned order that the action was taken under regulation 14, which contemplates that
Page 162.
which contemplate that where an officer concerned has absconded or he doesn't take part in the inquiry, or for any reasons to be recorded in writing, it is impracticable to communicate with him, or where the disciplinary authority for the reasons recorded in writing is satisfied, it is not reasonably practicable to follow the procedure prescribed in the said regulations, the competent authority is within its right to take a decision in respect of such officer. In the case in hand, the appellant's case is 2 notices were sent to the respondent. In fact, the learned counsel for the respondent has conceded to the fact that the respondent did receive the notices issued by the appellants. Despite those 2 notices, no response, the respondent did not join his duties, nor has communicated with the appellants. It was under those circumstances that a final notice got published in the newspaper, and the impugned order of dismissal was passed. Suffice to state that the respondents have followed the procedure under regulation 14, which regulation are statutory in nature, having been framed under the provisions of the under the provisions of section 79C of the Electricity Supply Act 1948. And in that sense, if the plea of the learned counsel for the respondent need to be accepted, then the regulation 14 shall become OTOs. The regulation being part of the regulations need to be given effect to in the letter and spirit, which we are of the view has been given by the appellants. That apart, we also find that the appellate authority is justified in noting the fact that the respondent was unauthorizedly absent even on previous occasions. If that be so, the plea of the learned counsel for the appellant that a compassionate view can be taken cannot be accepted. This we say for the reason that the respondent remained absent for almost 700 days.
783 days is.
How many?
783 days.
783
as per the dismissal order.
783 days. In the facts of this case, we are of the view that the order of the learned single judge is totally untenable. Full stop. The appeal filed by the appellants, the same is set aside. The appeal filed by the appellants is allowed, no cost.
Great.
Just say this one more paragraph. The learned counsel for the respondent had relied upon the judgment of this court in the case of Lal Mia versus Secretary KEB, ILR 1999, Karnataka 358, to contend that the procedure contemplated under Regulation 9 is required to be followed before any action to the prejudice of an employee can be taken. We have seen the judgment as placed as relied upon by the learned counsel for the respondent, but the same has no applicability in the facts of this case, more so when the issue which arises for consideration is an interplay between regulation 9 and 14. When the issue which arises for consideration is on an action taken by the appellants in terms of regulation 14 of the regulations. Full stop. In the said case, the court was only concerned with the applicability of regulation 9 and not an interplay between regulation 9 and 14.
Lordships may kindly see para 3 in this case. There was a reply that was given, and therefore it was held that an inquiry was required. If your Lordships may kindly take para 3. I apologize for interrupting. About the 9th line in para 3. If your Lordship see, since the explanation offered was not satisfactory, the employer issued one more recall notice. So he had in fact issued a reply.
But there also, my lord, the employee was dismissed without inquiry. Ultimately, my lord, in spite of reply, no inquiry was held.
So in those facts.
No. Here the action is under 9, not under 14.
Indeed.
Full stop. The aforesaid is clear from the fact that the disciplinary authority proceeded to frame the impugned order by exercising his power under regulation 9 of the regulations and dismissing the petitioner therein from the services of the board. Full stop. It is not such a case here, and as such the judgment is clearly distinguishable. This paragraph of judgment, just give it at the bottom, we will do it. Can you ask this?
Great.
Please, my lord. Petition by department, my lord, which the honorable tribunal directed to pay the interest, my lord, for the delayed settlement of the pension. In fact, there was a inquiry proceedings, my lord, which ultimately, my lord, exoneration order was passed by the Ministry of Finance as per Annexure D on 29/9/2022, my lord. In fact, it ended finally. Earlier, my lord,
when was he entitled to the pension?
Pension,
what was
my
the
lord,
earliest date he was entitled to?
that is, he has retired on 31/10/2012, my lord.
And what was the impediment for you to release the benefits then?
Because the inquiry was pending, my lord.
When the inquiry culminated finally?
Finally, my lord, according to us, on the order passed by the Ministry of Finance on 29/9/2022, my lord, because he has been exonerated. Earlier, my lord, there was a.
No. See, if there is a delay on your part, he should not be penalized.
That is there, my lord.
Okay, you may pass in 22 or 23, but you will say that is the date when he will get it. But
in
what
fact,
was
my
the earliest in law you were required to pass that order, or on fact, you are required to pass that order?
In fact, inquiry officer submitted report, my lord, on 12/2/2015. The 3 charges were there. So far as 2 charges are concerned, he has been exonerated. So 1 charge, my lord, charge 2. And again, disciplinary authority, my lord, on 3/3/2015, that charge is also been dropped, my lord. So honorable tribunal, my lord, has taken that date, my lord, next date.
Which is the date the tribunal taken? From 4/3/15.
4/3/2015, my lord.
That's right.
In fact, my lord, thereafter, my lord, we have sent the file for a second, that is stage opinion. So that is procedure adopted, my lord.
But what happened to the disagreement note?
Disagreement note, my lord, that is ultimately, my lord, turned down by that is Ministry of Finance, that's the ultimate.
No, but that disagreement note was of 15, now.
15, my lord.
So 15. Okay.
Please.
That was turned down by the Ministry of Finance.
That is 29-9.
That means your disagreement note was not correct.
No, disagreement note of the finding of the inquiry officer. So
right.
ultimately, my lord, it has gone in favor of the charged officer.
So the inquiry officer doesn't prove the charges. There is a disagreement.
So
note.
far as two is concerned.
There is a disagreement note. Did you send the disagreement note to the employee?
Yes, that procedure, he has filed a reply also for that.
Filed up. But that
So far as that is concerned, there is no dispute. Only thing is, my lord, whether there are two things, my lord, so far as gratuity is concerned, as well as leave encashment, my lord, both for that, my lord, the interest was ordered to be paid.
Yeah, that's right. That's right. And there is a specific order of 2008 writ petition.
The, 6 months time was granted.
And
In
take
fact-
in accordance with law, subsequent to which the inquiry officer submitted.
There is
Agree
160,
with the finding. Inquiry officer, see,
A5, my lord, 114.
what went in the favor of the employee is this. First round of litigation, 6 months time, you don't do it in 6 months. The inquiry officer acquits him, absolves him of all the charges. The disciplinary authority gives a disagreement note. Then the matter goes to the second stage advice.
Please.
The Ministry of Finance shot down the disagreement note. That's right.
No, in fact, my lord, the disciplinary authority disagreed with the inquiry officer.
Right, that's the
So
reason.
there itself, my lord, that ended. Because ultimately, my lord, the Ministry of Finance ultimately exonerated him,
So
dropping all the charges.
the disagreement note was not acted upon.
No, my.
That means the disagreement note which the disciplinary authority has proposed was not accepted.
Please,
That is the date taken by the tribunal.
that is the date.
Don't think we should.
Employee, at least, my lord, see, rule 68, my lord, only it refers to gratuity, not encashment, leave
Simple
encashment.
logic, it's just
Yes.
simple logic. He has been denied the benefit of monetary. Forget under the rules, even in a commercial, even in a contractual appointment, contractual in a contracts also, even in a civil disputes also, even a recovery also. Though under the rules, he may not be entitled to interest. Anything precludes the tribunal to grant interest because he could not enjoy the benefit of that amount. It's only that logic.
That is,
Just take down.
at least, my lord, rate, my lord, GPF rate, that is, it comes around.
How much has been given?
No, only GPF rate is mentioned, my lord.
That's all. You work it out. That's 6%.
No, it may come around 9.
He
my
will not say so. It's better for you to be governed by this. Whatever is the interest, suppose it is 4%, you will give 4%.
No, it comes, I'm told, my lord, 9% around. So if it is 6, made it 6, my lord. Anyhow, my lord, proceedings were pending, maybe, my lord.
Oh, see, this is the amendment. Just one. Can you just sit down?
Please.
Ma'am, can you sit down? Just sit. Just sit down. No, see, that's another issue. Proceedings are pending still.
No. During this, from 2015, my lord, I am to tell.
I don't know. The appeal has been filed, the petition has been filed challenging the order dated 21st August 2023 of the Central Administrative Tribunal in OA number 170/00224 of 2022, whereby the tribunal has allowed the OA filed by the respondent by stating as under page 38. The submission of learner counsel for the appellant is that the tribunal has erred in granting the interest to on the gratuity / leave encashment amounts with effect from 4/3/2015 as according to him, between 4/3/15, after 4/3/15, just say this, according to him, as on 4/3/15 and even thereafter, the proceedings were pending.
Pending till
Pending
29/9/22. That's annexure
Till which date?
29/9/22, madam,
29/9/22.
wherein the
When
Ministry
the
of Finance
Ministry of Finance has passed an order
exonerating in all the
exonerating the
annexure D, my lord,
respondent herein.
in page 224.
Respondent herein. We are unable to accept the said submission of the learned counsel for the appellants
Petition.
for the reason that the tribunal, while granting the interest, has in paragraph 9 stated as under. Stated as under. Full stop. Full stop. What is stated as under? What is also important is that just cut down. The basis for the tribunal to grant interest with effect from 4/3/2015 is primarily for the reason that the disagreement order dated 3/3/2015 of the disciplinary authority was 3/3/2015. It is this disagreement note which has been set aside by the Ministry of Finance on 29/9/2022. That's right?
No, in fact, my lord, 3/3/2015, that is disciplinary authority disagreed with the inquiry office. So inquiry officer held against the.
What is the date
So-
of Ministry? What is the date of Ministry of Finance?
That is 29/9/22, my lord. Exonerated all the charges.
Has set aside the disagreement note of the disciplinary authority and had in fact exonerated the respondent. So merely because merely because the process undertaken by the appellants had taken time cannot be to the prejudice of the appellant. More so when the Ministry of Finance itself, through their administrative machinery, has had absolved the respondent from the charges. Full stop. In fact, we find that the inquiry officer has also not proved the charges against the respondent. Full stop. In the facts of this case,
There one fact. So far as charge 2 is concerned, he has held that when it is proved, then disciplinary disagreed with it. Ultimately, then it has been exonerated by.
Inquiry officer has exonerated him.
Two charges. One is he has upheld, and disciplinary disagreed with. That is factual.
We will say in the facts. In the facts of this case, when the respondent has been absolved of all the charges, the only challenge to the grant of interest by the tribunal is not interfered with. Thank you.
Maybe 6%, my lord, if it is made.
We say nothing on that. We thought that it will inure to your benefit, whatever is the interest.
Anyhow.
See,
Please.
and there is a justification for them to say so. Whatever the rule recognizes the
Please.
interest, they have granted that.
Please.
31, Shri Radhakrishna Holla.
For the petitioner, my lord, the petitioner was appointed, he was the Gramin Dak Sevak, was deputed to Army Postal Service in 1997, my lord. My lord, GDS are not normally permissible the Postal Service. They have been promoted as Group D for a day by postal authorities, and there he continued as a Group D for 7 years, my lord. Thereafter, my lord, because he had some personal problems, his mother died, etc., he sought repatriation to the parent department that was permitted by the Army Postal Service. In 2004, my lord, he was repatriated. Now the question is, my lord, after repatriation, directly he was posted as GDS, even though he was working as a Group A. The relevant, the order says, my lord, he should continue as a Group D till either his services are terminated or he is provided a job in the civil department in Group D. My lord, that was not done, my lord, without following the principles of natural justice, my lord. He was reverted as GDS in 2004. And thereafter, he was posted to Kolar, some different unit, my lord. Subsequently, he was transferred to Bangalore, my lord. As a result, my lord, his seniority is affected. He could not get promotion till now, my lord, for Group D.
But tell us one thing,
Yes,
when were you promoted as the Group D?
1997, my lord, when he was deputed to Army Postal Services.
When were you deputed to APS, Army Postal Service?
My lord, that is on 17/10/1997.
But that was only an ad hoc promotion to Group D.
True. Only department, my lord. There in the army, this one is a regular promotion as a Group D.
When?
97 only, from 17/10/97 to till 2004.
Okay.
My lord, your lordship may kindly see annexure A8, my lord, the relevant rules, my lord. Issued by the government. Typed page is at page 60, my lord. Which says that is dated, my lord, 13/8/2007. Of course, by that he was repatriated. That's why the tribunal said these rules are not applicable. Nevertheless, my lord, no other rules are there. We have to fall back on these rules. Which says, my lord, from para 3, I will just read, my lord. GDS officials who are now proposed to be regularized as Group D from the date of their entry in APS technical promotion given earlier will not be reverted to civil till they are discharged from APS on the date of retirement as applicable to APS. However, Army Postal Directorate will make efforts to retain officials in APS itself till the civil date of superannuation. In case of reversion from APS to civil side, after attaining the retirement age in APS or thereafter, those officials will be redeployed on the extent Group D vacancies are available in civil. In cases where no civil Group D posts available to accommodate these personnel, then there will be no option but to proceed on termination direct from APS. An understanding to this effect should be obtained. In case GDS, who are now promoted to be regularized as Group D, are reverted to civil for some reason or the other, such personnel will rank junior most in the seniority in the civil gradation list. The date of assumption of charge in a civil post will be deemed to be the date of entry into the grade in the civil gradation list for the purpose of seniority. However, the service rendered in APS as Group D will for all
But
purposes.
tell us one thing.
Yes,
on your repatriation, what happened? On repatriation, where were you? Were you given Group D or GDS?
GDS, my lord.
So why didn't you protest then?
That is a thing. I admit that, my lord, that is a lapse on his part.
These are the conditions which they have put it. There has to be, see, one thing is there. You may have been promoted to Group D while before you went to APS.
Yes, my lord.
You went to APS?
Yes, my lord.
Then sought your repatriation?
Yes, my lord.
When you sought your repatriation, when you came back, you were posted as GDS.
Yes, my lord.
You continued on that.
Yes, my lord.
Then you sought your change of transfer to Bangalore.
No, I have been giving representation my lord, for promotion. From the date immediate, my junior in GDS is promoted as Group D. From that date, I am seeking promotion. Even my prayer before the CH-2, the CH-2 was that one only. Kindly promote me from the date my immediate junior in GDS is promoted. But then CH-2 took a technical view of the matter, my lord. Seniority, as per seniority list.
Whatever the conditions are applicable.
Now, while you were working in Kolar as GDS, you sought your transfer to Bangalore.
That is 2016, my lord.
That's right.
Yes.
But even before 2016, when you got yourself repatriated from APS, you were GDS? You continued as GDS?
My lord, that is not correct, my lord. I was the Group B. Group D.
It's all right. But Group.
Kindly consider this aspect, my lord. In 1997, my lord, I was covered by the old pension rules. Accordingly, deductions are made as per the old pension rules. Now, after my repatriation, my lord, the entire thing has been denied to me without giving an opportunity of being heard in violation of principles of natural justice. They should have given me an option, my lord, saying that these are the terms. If you are agreeable for this, you will be appointed as GDS.
Now, you see, come to this letter, come to page 25. Para J.
Yes, my lord. The
Para
applicant
J.
had voluntarily opted to,
No. Para J4. Page 25.
yes, there were clear instructions in the postal directorate letter number so and so, dated 28/7/1997, that I will not seek repatriation to the civil before my appointment to Group D cadre on my turn. Yes, I have given, my lord, no doubt, because of the unforeseen circumstances.
You're right. Let's see, they read it further.
And in case of reversion to civil or any unforeseen reasons before my return to appointment of Group D comes, I am ready to be accommodated in a post EDA if the present post is not applicable, available.
So,
Yes, my lord.
so based on this, you came as the EDS.
No, my lord. I came as Group D only, but I should have been given an option. Whether you accept now JDS or you want to be, the terminated service.
What is the effect of this clause? What is the effect of your undertaking?
His undertaking is there, my lord, but the annexure A8 overrules that. It says, annexure A8, which I just read before your lordship, it says that he has to be terminated with the Group D, or he has to be kept in the list till there is a Group D vacancy in the civil side is there.
Now you are claiming Group D from which date?
From the date I repatriated, either or from the date of my repatriation,
What is the date of repatriation?
that is 5/5/2004, or from my junior most in the GDS, he is promoted to Group D. It's a very reasonable request, my lord.
So when did you file the OA?
I filed way of, my lord, that is,
17 years.
yes, my lord.
How do you answer that? See, something which happened in 2004.
My lord, he's a GDS employee, my lord. It's the level of understanding,
Right,
lack
you're
of
right.
education.
Can we draw a distinction on that ground? Just tell us this.
No, my only question is, my lord, whether he can be demoted from the Group D to GDS without following the principles of natural justice.
This happened when, that's what we are asking. This happened when in 2004.
True, my lord, but merely because of delay of illegality cannot become legal.
Tell us, no, that you can't justify it that way, please. Tell us, any of the juniors got Group D?
Yes, my lord.
When?
I have given representation also.
When?
2016, my lord, of course.
2016,
I have given. That is, he has given the list also, page 80. Connection A14.
When did the junior got?
Junior got, because I don't know, because there are so many units.
Yeah,
Only department will be able to tell that. What they have given information, my lord, I am producing at page 80, annexure A14. They have given the names only in 2016, 17, etc. They have not given the figures from 2004. What has happened from 2004? Because there is no common seniority list, my lord, as in other cadres. It's a GDS employee appointed for a particular post office.
And it appears where somewhere, I think the tribunal also records, you could not able to give the date when the junior got.
Obviously, my lord, because I have appointed the caller at a particular post office. How do you know the seniority of all the GDS working in the region or the state?
Okay.
Only department will be able to say that.
Now, what is your year of seniority?
2000, my seniority 97, my lord, as per this one, when I went to Army, APS, that is the date as a Group D, I was appointed. 2004, I came back. From 2004, my lord, of course, my junior most, who is there, was, promoted as Group D, that whole department knows it. Because they keep all the records, custodian of records.
Ma'am, where is your reply before the trial? We'll come back after lunch.
Please.
Serial number 32. My lords, there was a direction to serve on the panel advocate. However, she is out of station, my lords. May request for a short accommodation.
We'll just show us this. 32. We'll hear you. Let's see.
There is a parter matter in quota number 1. Maybe it will take tomorrow, my lords.
If you just go there, do your matter. If you are unable, we will accommodate.
Please.
Okay.
Serial number,
Just note down this matter.
serial number 35, my lord. My learned friend, petitioner advocate is there. Next week, my lord. B group.
First or sixth.
Who is the other side?
He is
Yes,
there.
yes.
What is the
It's-
difficulty?
Please,
Difficulty?
some difficult one, pass over matter. Next date I will do. Short date maybe, any convenient date. He's only asking for parity with the earlier repetition, my lord. So vigilance angle was pending. He has not been cleared, in fact. Now he has.
But suspension also is a bar for promotion. You will put it in seal cover, na?
No, that was
Please,
revoked
ma'am.
subsequent,
Because
but all period has been treated as duty.
Huh?
Suspension period also has been treated as duty.
Duty?
Yes.
But penalty, my lord, who stage lower
That is
has been
subsequent.
awarded. That he has
Have it
not checked.
tomorrow.
Lord,
Tomorrow.
Tomorrow.
Serial number
kindly, serial number
36.
10, serial number 10, it's
Why not?
passed over.
My lord, tomorrow I'm having another case.
Day
Debt-
after tomorrow.
debt.
Yep.
Obligation.
Yes.
Serial number 10, my lord.
Hmm.
Lord, passed over. Lord,
See, why an appeal is filed, Mr. Charati? Tell us.
Lord, the observation of the learned single judge at para 15, which will not permit me to take my own decision because the order of the learned single judge has already curtailed my decision-making process. That's why, my lord, an appeal is filed.
Which paragraph?
Lord, Lordships had looked into the operative portion, my lord. Now, may I request your Lordships to kindly take page 33, para 15, my lord. Para 15. Well, my lord, what had earlier happened is this area was relinquished to me. Subsequently, the National Highway did not come. For that purpose, my lord, they are seeking for a TDR. A writ petition was filed. My decision was set aside. Writ appeal was allowed in my favor.
This estoppel would be coming against you.
Yes, my lord. This observation, but the findings of the
And you
division,
appear for the respondent.
No, my lord, it's minus.
it's yet to be ordered, my lord. Lordship, I'll remove the office objection. There
How many are there?
4 are there, my lord.
Because the council, for 2 weeks are granted to remove the objections.
Yes.
Let's see
45.
him.
Just give a date.
Please.
Just 1 minute. Let's have it.
14/8, sir.
14th August.
Please.
14/8.
Okay.
My lord, it's third.
Hmm. Hmm. What is the date there? 2nd August. Is it a connected matter to this? Say. Who is the other side here? We'll have it on 2nd August. Re-notify on 2nd August. Just say only this.
That's serial number 36, my lord.
Yes, ma'am.
I'm sorry to mention again, the petitioner counsel is present, my lords. A short accommodation anytime this week is also fine. my
And
lords.
for the petitioner.
At the request of counsel for
Respondents, my lords.
respondents re-notify. Just give any date in the week.
Date may kindly be fixed.
12/8.
Yes.
31.
Yes, my lord.
My lord, I am urging only these 3 points, my lord. Number one, he lost his pensionary benefits, my lord, otherwise he would have entitled from 1997. Secondly, my lord, he was not reverted to GDS in accordance with law. Just now after completion of his, Group D post, in 2004, he was just posted from transfer after transfer. Regarding seniority, my lord, it is not possible for me to determine was my immediate junior, etc. But the postal department will be able to see that, my lord. That's-
That the year has been given promoted as Group D. Possibly we could have, or possibly we would have asked them also. Not even your case also that a junior has been promoted.
Yes, I have given representation and also at page 80, I have given the names of the persons.
Do you have any idea?
My lord, at the time of deputation, whatever the terms and conditions are applicable, is applicable in the case of the petitioner, my lord. My lord, I have produced the notification dated 28 May 1997 for which was for the deputation to APS, my lord. It says, my lord, it is produced at page number 102 of the writ petition. Typed copies at 104, my lord. The Army Postal Service has brought to the notice of this directorate about the acute shortage of Group D officials in their organization. This problem has been examined in detail and it has been decided that to tide over the situation. EDS may be deputed to the APS after giving them technical promotion to Group D for a day for manning Group D positions in APS on long-term basis. The EDS who are willing for deputation to APS may be selected only after they are found to be medically fit for APS files, APS file service. After selection, the clear understanding may be obtained from the EDS before their technical.
Very difficult.
This is applicable for him, my lord. This notification, after repatriation, he was JDS in Pola. If it would have been his case that at the time of repatriation only he was Group D, then he had to ask at that time.
That time there was no Group D, junior. He continued as GDS.
Yes.
What he is saying is he doesn't know any junior has been promoted as Group D. And see that page 104. I fully understand that after the promotion to Group D cadre, I will be entitled to service candidate at par with the junior.
My lord, kindly see.
If you see the.
Yes, my lord. In case of, yes, my lord. Yes, my lord.
Before my term of appointment, I may.
Yes.
I may ready to be accommodated post of EDA, the present post is not available. If no post of EDA is available, it will.
My lord, there is nothing on record to show that whether date of my repatriation, there was a vacant post of Group D. That has not been considered.
It's quite late in the day.
I have noted this.
Late in the day, 2004, and we don't know. Do you have any information, any of his junior for Group D?
I don't have.
That is, they can find out, my lord, because date of appointment is there as GDS in the postal department. Or date of appointment is available with them. My date of appointment as GDS, as also other GDSs, they can easily find out who are all juniors. Yes.
As per the documents produced by him only, all got promoted during 2016 and 17, my lord.
No. No.
I don't have that instruction, whether they are juniors or senior to him, but.
See, otherwise, see what will happen if he doesn't succeed in this petition, he will be stagnating there.
But still he may not get, my lord, because he got promotion under Rule 3 also, from JDS to GPO Bangalore. My lord, kindly see page number 61, my lord. Under Rule 3 of JDS C and E rules. He got transferred.
Transfer, yes.
Now he became GPO. No,
At page number 61, my lord.
that's right.
His transfer is under rule 3 of the GDS.
Down in the seniority. His seniority would be down of this place.
Yes.
My lord, if my senior is counted by 2016, my lord, it is as good as dismissing this OAL, because I won't get at all.
He will not get any seniority.
You will not get any.
I will not get this, group D if my seniority is considered from 2016.
When we told this obviously, in 2016, when he came to Bangalore, he should be.
No, 2004, my lord.
2004, we are not in. See, that's simple for the reason 104 you will see. 104 you will see. I will not seek repatriation to the civil before my appointment to Group B cadre on my terms. It is not your case in 2004 that you became eligible, juniors have been promoted as Group B. And that in any case is part by time. I don't think then we should take it.
At that time, no junior got promoted, my lord, during 2004.
Have you said so? And in repatriation from APS, any of the junior was promoted as Group B?
No, we didn't say so. During 2007 only, the Group D employees were regularized in APS.
Which year?
2007. Before that only, he got repatriation. 2007, all the Group D employees were regularized in APS.
If the juniors got regularized.
I have to take instruction in that regard. But though the juniors got regularized in APS, that is not applicable to the.
It is not,
From APS.
Yes.
So there is no question of
Yes.
regularization, his regularization in APS.
Yes.
We want to know after 2004 when he has come back, any of the juniors have become Group B.
I will take instructions in this.
Just take instruction.
Please.
Let him, if he can get the reading, let him be with benefit. We have heard the counsel of the response. For the respondent can take instructions as to whether any of the juniors, as to whether any of the juniors to the institution has been promoted to Group B after 2004. EPS, the date of success.
Please.
If you want.
4 or 5 days. 4 or 5 days. Next week, kindly. Yes.
5/8, 5th of August.
Please.
My lord, serial number 32, my lord. Are you counsel is in court on number 1, my lord? Kindly have it on tomorrow, my lord.
Madam.
Let it come. If he is through with the court, let it come.
230 first matter is going on, my lord. First matter only, my lord. Kindly have it on tomorrow, my lord.
My lords, in submission, my lords, respondent number 2, on behalf of my lords, respondent number counsel, she is not well, my lords, she is in hometown, at least 3 days she is required. And my lords, they have not served the copy also, my lords.
We will serve, my lord. We are trying to reach him, my lord. He is out of station, my lord.
It may be a Friday or Monday, my lords.
You see, let them come tomorrow. You also be there.
Please.
Just give me copy.
Yes, my lord. I will serve. Yes, ma'am. Much obliged.
30th 7, madam. 17. Serial number 17, passed over matter. The Prithvish.
Yes.
Let's, I've gone through that. Let my NDVR before your lordship. And may I say this, my lord, I'm not going to open my account with the dismissal before your.
Open the file.
My endeavor before your lordship, my lords, is to, my lords, to show, my lords, that I've made my points, my lords. I'll exactly take your lordships to that. Your lordships pointedly asked me whether the author of the document, Exhibit P38, which was not in the list of documents, has been examined. My lords, my answer to that is no. Did I have an opportunity to cross-examine on that document, my lords? The document was marked on 311. My lords, I'm not, my lords, and I don't have the records or the proceedings before me, my lords, to say whether I had an opportunity to what. My lords, the facts would go like this, my lords, because relevant facts, why I'm pointing it out, my lords, is to establish before your lordships that there's a real likelihood of bias. And that's how, my lords, I'm just pointing this out. The additional superintendent of posts would conduct an internal inquiry. He would examine various persons, record statements, submit a report to the senior superintendent of posts. The senior superintendent of posts, my lord, would issue the articles of charge, appoint a lower cadre officer, that is the inspector of posts. And I'm saying he is lower in cadre to the assistant superintendent of posts who conducted the internal inquiry. Now, my lords, during the course of inquiry, the senior officer who had conducted the internal inquiry is also examined as a witness. And the documents that are marked before the inquiry officer are predominantly the statements which were recorded by the additional superintendent of posts. And of course, my lords, there are one or two other documents which are marked. I'm not saying, but predominantly all were the statements made before the additional superintendent of posts. Now, during the course of such examination, one document, that is Exhibit P38, is let in by witness number 27. Now, my lords, whether that is a crucial document or not is one of the questions that your lordship posed to me. And I'll point out from the inquiry report that the inquiry officer, in respect of each and every charge, has heavily relied upon the document. And thereafter, my lords, would come to the conclusion, my lords, that my lords, I have submitted my appeal. In appeal, my lords, an interesting point has been noted by the appellate authority. He says that we offered all the delinquent officials and to pay about 2,50,000, concession was made, my lords, for me to pay 2,50,000 and for the remaining 5 of them together to pay 2,50,000 together above. I would, my lord, have produced that records to say that I disagreed with it and said that you are holding inquiry, where is the question of me admitting to it and paying it? Whereas, my lords, the others paid that amount. Therefore, my lords, no inquiry was conducted against them at all. Against one other person, inquiry was conducted on the last day of retirement. He was visited with the penalty of compulsory retirement. Now, insofar as I am concerned, the appellate authority would say, look, we offered this concession to you earlier, that you pay 2,50,000. You did not take that concession from us. Therefore, we are not going to give you a concession here and reduce the penalty, and therefore we uphold the penalty of removal. That's right, Malik. And I have produced that letter where they asked me to pay. I refused. And the appellate authority would, the charges 1 to 7 are essentially this, of course, in respect of each person they have made. 1 to 7 is that I have issued the ATM cards in the Department of Posts without verifying whether the account holder is alive or not. The substratum of the allegation is that the account holders are all dead. Now, you have either issued or verified for issuance of the card without verifying whether that person is alive. Insofar as charge number 8, my lords, that is held to be not proved by the inquiry officer, the disciplinary authority would submit a disagreement note. The disagreement note, my lords, by its language and in the opinion of the disciplinary authority is also not tentative. It straight away says, we are disagreeing with the findings of the inquiry officer. They say so. May I just draw your lordship's attention to that inquiry report? Yoginath Babde, Kunj Bihari Mishra. The tribunal, my lord, essentially, my lords, does not go on that, essentially goes on the merits. I have raised that contention, but have I relied on those judgments? No. That's why I said, my lord, I have a borderline case, because there are certain things which I have raised here. And one more interesting fact is, my lord, when there is during the course of inquiry, I have not examined myself as a witness. Therefore, my lords, the inquiry officer ought to put to me the questions in relation to the evidence that has been let in. 1418. Well, it appears that procedure is followed, but what were the questions that were put in? What were my answers? And how does it materially affect or alter the case? It is not even considered by the inquiry officer. Inquiry officer in the beginning says, on 311, CO was given an opportunity to put in his defense or to ask mandatory question. He opted for mandatory questions, therefore they were asked. Now, what were the exact questions? Whether it was in relation to the evidence that was appearing against me in the course of inquiry, what were my answers to that? And therefore, my lords, whether my case ought to be considered or not. And in my second show cause notice, my lords, I have specifically stated in relation to Exhibit P38 that, look, this was not a document which was marked. It is an external document and it is not proved in the inquiry. I've taken that defense.
You say on this.
Actually, that document, that is clearly discussed in the.
P38. 2010-2020 months. I presuppose that question also, but 1115 would in fact cast a duty on the inquiry officer. Now, because he had to give a list of the documents, the presenting officer had to give the list of additional documents, and then should I seek time? But whether those documents were in fact given as a matter of fact, as a list, and whether, my lords, I was asked, given an opportunity.
That can be seen from the order sheet.
Order sheet. That order sheet, my lords, I don't have.
Yes, ma'am.
Which time you?
2 weeks, ma'am.
Great.
20th August, sir.
Please.
17, sir.
Back to your lordship with a better case next time. I'll come back to your lordship with a better case next time. Great. Great.
Where date is 17.
21 is. 20th, sir. Serial number 27, Shri Narasimha Swami.
Sorry, my lord, I'm sorry, I was before another court. My colleague could not come online, so matter is passed over. This case, my lord, what has happened is, there's a marginal delay of 33 days. The workers writ appeal, this is the workers writ appeal. The counsel who was appearing for him, he has retired, he is not practicing. So there was some communication gap between the counsel and the worker. So he could not immediately approach the advocate and take back the papers. In fact, as a matter of fact, I am yet to get the full set of papers. Only on the limited papers I have filed the appeal. So he could not get back the entire paper. So that took some time. Hence, there is a delay. That is what is being pleaded also. It is a fact. Worker, I am for the worker. In this case, I am for the worker. The delay, reason for the delay is, I am for the appellant. On merits, my lord, this is a approval application which was rejected before the tribunal 33(2)(b). Against that, the management filed a writ petition on the sole ground that the tribunal has interfered under 11A, which ought not to have interfered. The entire order could be seen. Nowhere the tribunal states that I am interfering under 11A. Absolutely incorrect contention taken up by the management. I do admit that under 11A cannot be invoked for a proceedings under 33(2)(b). 11A could be invoked only under 10(4)(a) or 11(1)(c). 33(2)(b), 11A is not applicable. But the only ground on which the writ petition was filed by the management is the tribunal has invoked 11A. 11A cannot be invoked. Learned single, it is 33(2)(b), approval. It is not there. It is, that's all. That's all. Compliance of 33(2)(b). Three points. One is inquiry fair and proper. Victimization. That is what is being interfered in this case. Victimization, discrimination. Only two aspects. As per the Jaipur Jilla decision, the tribunal can interfere under. The others were he was a union member. He was a union office bearer. He has been victimized. That has come in evidence and that has come in the order also. No. Only to destroy that particular union, he was issued with a charge sheet. The charge sheet was issued not only to him, another office bearer of the same union. That I need some time, man. I'll demonstrate. Only a week's time may be granted. Disproportionate. Yes. But the tribunal also could interfere in the, as your lordship rightly pointed out, victimization issue. Court has gone into victimization aspect. Yes, that is. Of course, proportionality. Yes. On the ground that 11A cannot be invoked in 33(2)(b). Learned single judge has set aside the order of the tribunal on the ground that 11A cannot be invoked. I do admit 11A cannot be invoked. And tribunal has not invoked 11A at all. Here in this particular that aspect. No, court has gone into the only the victimization aspect. Union office bearer he was. Victimization aspect he has gone. Victimization. That is the main aspect on which the
what is this page 42?
I need some time, my lord. I need, please, madam.
It has been set aside.
I will convince. Please. Next week.
7-8.
Please.
Hearing matters. Hearing number 38, Bhushan Ji.
Appeal for the petitioner. My lord, I appear for the respondents, my lord. Submission, my lord. I'm suffering from fever and headache. I've been not able to come out of home. I'm appearing from home. 3 weeks time.
My lords,
My lords, the petitioner, in response to Central Employment Notification 1 of 2015. Please, madam. Please. My lords, what has happened is, before the Honorable CAT, my lords, I am originally in the first order which, but that was modified, my lords. The word telecommunication was, please, my lords. Please, my lords.
The medical examination.
Please.
Not the subject matter before tribunal.
Please, my lords.
The fresh cause of action. This order of your appointment, of the medical examination, was after you were given the appointment letter.
Please, my lords.
The fresh cause of action. You have gone to the tribunal.
My lords, in the medical examination, my lords, according to the note, not as such, my lords. What?
Sure.
My lords, what the difficulty is, my lords, in the medical examination, according to the notification of 2015, the medical category eligibility is taken into consideration, my lords. What I am seeking before this honorable court,
But you did not go again after that medical examination.
I haven't appealed it, my lords. I haven't appealed the medical examination. My lords,
Okay, now you look into it when you have not challenged the medical exam.
my lords, my medical eligibility in eye is actually below 2 diopters, my lords. As per the, there is no issue as such, my lords. But the only relaxation, no, my lords, I'm not saying I'm fit, my lords. But the only difficulty is, my lords, I'm seeking for relaxation, my lords, because in 2018 notification, that is done away with. And I fall right into the medical eligibility if the subsequent notification is taken into consideration. I can, my vision will be qualified, my lords.
Go to the tribunal, challenge that medical, they can also be prayer, that for relaxation. Today, they didn't have the opportunity to reply on your medical examination. There would be that, if you think because of the subsequent listing, they had relaxed the standard. Go ahead.
My lords, the difficulty would remain, my lords, either ways, because my,
Relaxation.
no, after relaxation, the difficulty wouldn't. I will be on a little bit of a shaky ground, my lords, even like that. Only if that relaxation is given, my lords, and if I fall into mechanical
Mechanical discipline.
please,
Change your appointment to mechanical discipline. Have they done
please,
it?
please.
They have given you the appointment letter also.
They've given me the offer as well.
There is no issue.
There is no issue. There,
With your eyes.
please, that is the core of my issue, my lords. That concept.
They have actually gone to the. They have actually gone to the tribunal. Look here, this is how they have dislodged me. They have disqualified me on the ground of IAMC. My submission is that I am entitled to relaxation. And this is the ground for relaxation. Say so, let the tribunal look into it. Now, what does
Please.
the tribunal say here?
The tribunal only makes this correction, my lords. Replacing the word mechanical with, that is all.
Go to the tribunal.
Please, my lords.
Please say this. After some submissions, he wants to go to the tribunal.
Please, my lord. My lord, your lordships are inaudible.
Oh, I'm sorry. My mistake, sorry. See, he wants to go to the tribunal. He wants to challenge that medical board outcome.
Please, my lord, let him challenge.
After some submissions, learned counsel for the petitioner seeks to withdraw the writ petition to challenge the proceedings of the medical board. Medical board before the Central Administrative Tribunal, Bangalore bench. Full stop. Noting the said submission, comma, the petition is dismissed as withdrawn. Suffice to, what is your apprehension?
My lords, the word mechanical has to be put back, my lords. The correction shouldn't be carried out. Because I qualify under the cutoff only for mechanical, my lords, not for signal or telecommunication.
Where is the corrigendum?
Corrigendum is at annexure H, my lords.
Annexure?
H, at page number 114.
Mechanical. They have put mechanical, na?
They've replaced.
Oh, with telecommunication.
Please, my lords. I don't actually qualify for, I'm not within the cutoff for telecommunication, my lords.
Then why did you ask for this? Who did this?
This is an MA filed by the second respondent, my lords, asking for the correction. And based on that MA,
What was your prayer?
My prayer was to
Telecommunication or mechanical?
mechanical, my lords, because I qualify only for mechanical.
But did you appear when this order was passed?
Please, my lords, I did appear.
Then why didn't you protest?
I did appear, I did protest, my lords, saying that I don't qualify because this is the cutoff list of the
Your application for
application is for appointment, my lords.
which post?
Specific,
Senior engineer?
not specifically, my lords, but for junior engineer.
Just a general description.
Please, my lords, because
And you applied for which post?
I applied for mechanical and I also qualify for signal and telecommunication, but I don't clear the cutoff in both of these specializations.
In mechanical, you qualified?
Only mechanical I qualify. This is the cutoff list, my lords.
Okay. This is. Now you have understood what is he arguing?
My lord,
He says the word mechanical, which has been put at page 114,
please. Go.
that should not have been done.
That I've passed on the cutoff list, my lords.
No, we
I
got your
score
point.
47.62.
But tell us one thing.
Please.
Let's assume for a moment, this goes to mechanical, but still you have not cleared the medical.
Please, my lords, I will
That is going to help you.
I will raise the issue of reconsidering my medical before the honorable tribunal. But this correction ought to be carried out. Modification.
This is
My
mechanical.
lord, page number 105, my lord. The misapplication for correction that we have filed, paragraph number 4, if I may read out.
Yes.
It is submitted that during the course of hearing in OA 1055 of 2018, a request was received from Principal Chief Personnel Officer, Southwestern Railway, Hubli, for supply of one RRB paper for the post of JE Telecommunication. And the applicant was provisionally selected for the post of JE Telecommunication and was recommended to Southwestern Railway for further necessary action. So and so. So,
My lords, if I may, these
so
documents
the prayer
were not.
in the misapplication, the prayer is, it's on page number 106. Now. So under the above said circumstances, it is most respectfully submitted that this honorable court may kindly be pleased to direct the office to correct the mistake by deleting the word mechanical in para 2, page 3, and insert word telecommunication and issue fresh certified copy of order dated 2nd April.
No, he says he doesn't qualify for telecommunication. He doesn't meet the cutoff.
My lord, in this regard, I have to seek instructions.
No, he says you revert back to the word mechanical. What do you say?
I need to seek instructions on this, my lord.
Did you oppose that application?
My lords, there was no opportunity given past this MA which was filed, my lords. It came up before the court and then the court ended up deciding that
The counsel for the petitioner would submit that the impugned order of the tribunal, which has been corrected by the tribunal itself, whereby the word word mechanical has been replaced by the word telecommunication in para 2 of its order is erroneous. According to him, the petitioner had applied for mechanical,
Please, my
junior engineer mechanical,
please, my lords.
and not for telecommunication.
I qualified, my lords, but I didn't qualify within the cutoff.
You applied for junior engineer mechanical
Mechanical and also telecommunication, all of it.
and
But I,
also for telecommunication. But since the petitioner doesn't fall within the cutoff marks, comma, it's a futility, it's an exercise in futility in as much as he will not be appointed to the post of junior engineer in telecommunication. He states that his case be considered for appointment as junior engineer mechanical.
please.
On this, the learner counsel for the respondent seeks some time to take instructions at his request, re-notify.
A definite date may kindly be.
5/8, sir.
5th of August.
Please.
Serial number 39, Shri Satyanand.
Wait for the respondent in both the matters. 39.1 is the main matter, my lords. (39.1) is the main matter. The second matter is filed by corporation, that is tagged down.
Insofar as first matter, my lord, is concerned, it is filed by BBMP.
What is the issue here?
Issue, my lord, is the family dispute which has been settled already by the father executing a will and gift deed in favor of the daughters and will in favor of the sons. That family dispute is sought to be settled through invoking the BBMP jurisdiction by making certain complaints to BBMP saying that some road has been blocked and some such thing, public road has been blocked, making a grievance. And a show cause notice, my lord, which has been issued. A writ petition is filed saying that these show cause notices should be implemented. That is the first aspect of the matter. That is the dispute here.
Lord, sir.
Secondly, may I submit? Please, let me complete. Secondly, my lord, the challenge to the writ petition is one thing. What relief has been granted by the learned single judge is totally different. Even if the writ petition had been allowed, the relief has been granted by the learned single judge could not have been granted in view of the prayers that are sought for in the writ petition. That is the second aspect of the matter. Third aspect, my lord, the learned single judge has erred in dealing with this writ petition as if it is a public interest litigation, making certain general observations, issuing certain general directions, and making some declarations which are not even sought for in the writ petition. That is the third aspect. The fourth aspect of the matter is the learned single judge sitting in writ jurisdiction has literally overturned the judgment and decree passed by a court of competent civil jurisdiction. No prayer for that. And has held that such judgment is not at all.
Between the same parties.
Between the corporation and myself.
It was not a party.
The
Fraud played on the court, my lord.
he has not even pleaded it, he has not even sought for it. And if fraud has been played, he can always file another suit and saying that this is not binding on me, or he should plead fraud in the writ petition and say this judgment is obtained without the absence of any pleadings. Without the absence of any prayer to that effect, the order passed by the court of competent jurisdiction has been literally set aside and has been declared that it is not binding on the corporation. These are the issues, my lord, which fall for my lord's consideration. My lord permits me.
I will
I'll-
take only 1 minute of your lordship's time. The matter is, I am the sister. Brothers and my father bifurcated the property and reserved 6,000 square feet as road and vested it in the corporation by deeming fiction. Now thereafter, that road was encroached. The commissioner,
No, no.
I will, please permit me to.
No, kindly, let me finish,
No, I'll-
because I am the appellant.
1 minute, please. Don't raise your voice.
The commissioner initiated detailed proceedings and verified with the revenue office whether during the time of bifurcation of Kata, this was treated as a road. Revenue office gave a report that this is a road and it was virtually vested in the corporation and this has to be displayed. They blocked that passage and prevented me from putting up further construction in my portion of the property which was gifted my father. Then commissioner passed order under a delegate of the commissioner passed an order. That was sought to be implemented. In the meanwhile, that was not implemented. I moved this honorable court directing the corporation, BBM, Brihat Bengaluru Mahanagarapalike, to implement the orders of its commissioner. They did not challenge the order of the commissioner. I sought for implementation. In that, initially, the commissioner came before this honorable court to delegate and said, we will implement our orders. This single judge recorded that affidavit and directed the corporation to implement. That was challenged before the division bench, stating that private parties were not heard in the matter. Matter was remanded back to the single judge. Now again, a single judge has passed a very considered order, which will go a long way for Bangalore in respect of these type of matters. He has given certain directions to the corporation in respect of roads vesting by bifurcation in private partition. Now, what is wrong in that order? My learned friends have to argue. I am only seeking for implementation of the orders of the commissioner. They have not challenged the orders of the commissioner, Bellot. That is wrong on the part of my learned friend to say they have challenged the orders of the commissioner. I am only seeking for implementation of the orders of the commissioner. Single judge has said you implement it now. But detailed order, well considered order. And he has issued certain directions to the corporation in future in respect of these matters where roads vest in the corporation by virtue of private bifurcation, partition, and then citizens should not be affected by that. That direction.
Tell us, how come a road will come between, in a case of partition between two individuals?
No, sanction plans are issued for both of us based on that road. If sanction plans were not issued, considering that as a road, once sanctions plans are issued, that roads vest in the corporation. That is how I'll argue the matter. Sanction plans are issued. If now it is not treated as a road, what will happen to the sanction plan? They have taken benefit showing that as a road. And the concept of road is there in the Municipal Corporation Act, how it will vest in the corporation, how the encroachment has to be. I am only seeking for removal of encroachment.
What kind of an encroachment?
A road is blocked now, my lords. I am not able to access my property at the backside. Half construction is there. I have got a sanction plan from the corporation based on that road. They have also obtained sanction plan based on that road. Now they are telling it is a private road, blocked it by virtue of a gate. 2014, my lords.
They say private road.
Private road. And commissioner has already passed an order treating it as a public road that is not under challenge. They did not challenge it. They were parties to that. Notice was issued to them. They replied. There afterwards, considered order was passed and proceedings are produced. I have translated copy of the proceedings of the corporation, which shows at the time of bifurcation of Kata, this was treated as a road. If this man.
No, but this petition was based on a decree.
No, my lords. That decree, my lords, what happened? Corporation issued notice to them. Thereafter, they filed a suit without impleading me as a party against the corporation. And the racket in this city is corporation doesn't contest the suits.
What is the prayer in their suit?
Permanent injunction. Not even declaration. Permanent injunction. That is what the single judge comments.
What is the ground for seeking permanent injunction?
That the corporation has issued a notice, they give injunction and not making a party. Notice was issued based on my complaint and they were notified regarding my complaint and I was not made a party. And single judge has come down heavily on the corporation.
But they appear for, you appear for the corporation, na?
No, no.
I
I am-
represent the corporation.
May,
Ah,
please, may I
you
submit, my
appear
lords,
for the,
if my
who
lords
appears
permit,
for the
may I
appellants?
commence my arguments?
No, we want to know who appears for the appellants.
I appear for the appellants.
First
Yes,
matter,
I-
corporation.
First matter, my lord, I represent the corporation.
Okay.
In the second matter, my learned friend appeared.
Corporation regarding some observations they have come, not regard through main matter, merits of the matter, observations.
How long you would take?
Certain
My
directions.
lords,
How long you would take?
it may take at least an hour, my lords, or more than that.
You do one thing, file your submissions.
Please,
I have filed synopsis, my lord.
You have filed
Short
your
synopsis.
Just see this.
the lordship may fix a date, my lord, on that day.
Fix a date. We'll fix
Please,
it.
please.
The counsel for the parties to file their written submissions along with the judgments they want to rely upon. Bracket में, in both the appeals. In both the appeals, within 2 weeks,
Please, my lords.
re-notify them. Let's see. But possibly you may have to abridge your submissions.
See, I'll try to complete within half an hour, my lord, not more than that. I'll try to complete my
Not take
submissions
more
within
than-
half an
Have
hour.
the benefit of the submissions, they can.
Please, please.
22/8, sir.
22,
8.
8,
I'm grateful.
oblige. Or can it be, my lord, in the last week of August, my lord?
Whatever.
Because 20 up to 22, I have some difficulty, my lord.
29.
Therefore,
29/8.
29, oblige.
29th.
Interim order, if any, to continue
29th, I have some inconvenience.
between both of you.
30th, 30th,
30th, let it be on.
30th.
Please.
Interim order, my lord, has to be
Interim
extended.
order, if any, to continue.
Please, my lord.
That's from 2014, I am prevented from putting up construction at 2:30 if it is convenient for the honorable court. I am sorry, my lords, I am seeking for request.
2:30.
Grateful, my lords.
Please.
30th is Friday. 1 minute, please. 30th is Friday. We'll have it some other day. Then either we can have 29th or 28th. Just see the diary.
28 should be quite fine with me. 28.
28,
28.
2:30.
I am
Please,
grateful.
28 to oblige me.
Serial number 40.
Sixth respondent, on behalf of the appellant.
This also. We will have it tomorrow this morning.
No difficulty. Lord, I have also filed a synopsis. I'll ask my advocate on record to verify whether it's part of the record.
You
That
see
had
that?
come up a long time ago. I'm not sure whether the synopsis on record. Well, we can always do that later. Yeah, citations and synopsis, yeah.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ ಸರ್
ಜ್ಞಾಪಕ ಇಲ್ಲ ಫೈಲ್
ಅದೇ.
ಆಗಿದೆ
ಕಾಪಿ has not been served, my lord. I am requesting my friend to file
Synopsis.
synopsis.
Everyone has filed the synopsis.
I have not filed, I will file it.
File, learner counsel for the, but we will be able to do it. See, why we have fixing it tomorrow is that appear there are connected matters which are coming today. Tomorrow,
Tomorrow, my lord.
we want to know.
This.
May I request for another 2-3 days extension?
We'll have it tomorrow, then we will see it.
Please, my lord. Because synopsis, my lord, takes some time to prepare.
Hmm?
Just
This
2
is a
days
case
time.
where I purchased the granted land prior to the act itself. So my case stands slightly on a different footing that the act never applied to me.
This is over. It has come. No, this can't be listed tomorrow.
This is to go.
This is over. Okay. Ma'am, this is. Tendency, no? Just give a date tomorrow. We'll have it tomorrow.
Very well. Great. Much
We'll
up.
get up. Yes,
The electrocution matters. I'm filing my rejoinder submissions.
take it.
I've served a copy to the respondents.
Madam? Madam? ಇದಾಕಿಟ್ರಿ ಮೇಡಮ್ ಯಾಕಿಟ್ರಿ ಈಗ
ಅವಾಗಿಂದನೂ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ಗೆ ಕೊಟ್ಟಾರೆ. ಫೋನ್ ಮಾಡಿ ಕೇಳಿ. ಹಲೋ ಸರ್, ಹಲೋ,
Yes.
audible sir?
Yes, audible.
Okay, thank you.
Dharwad bench,
ಎಸ್ ಮೇಡಮ್.
ಮೇಡಮ್ ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದಾರಾ?
ಫೋನ್ ಮಾಡ್ತಾ ಇದಾರೆ ಮೇಡಮ್, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಫೋನ್ ಮಾಡ್ತಾ ಇದಾರೆ.
ಹ್ಮ್ ಬಂದಾಗ ಬರೋ ನಂಗೆ ಹೇಳ್ಬೇಕ್ರೆ ನಾನು ಸಾಹೇಬ್ರು ಇಲ್ಲಿಂದ ಕರಿಬೇಕು. ಇದನ್ನ ಇನ್ನು ಫೈಲು ಅಲ್ಲೇ ಇದೆ. ಆಮೇಲೆ ಅಲ್ಲೊಂದು ಇಮೇಲ್ ಮಾಡಿದ್ದಾರೆ. ಬಂದೇ ಬಿಟ್ರು. ಸರ್ ಸಾಹೇಬ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದೀನಿ ಸರ್, ಬರ್ತಾ ಇದ್ದಾರೆ.
Good afternoon, brother.
Am I audible?
Yes, now you are audible. Good. Yes.
Lord, I was continuing my submission, my lord, but your lordships put some questions to table.
As I'm led by Mr. Sriranga, who is online.
But last time, specific information was sought from our side, my lord, with regard to the vacancies that were available at a particular point in time, and also, my lord, the eligibility that was acquired by these persons who were appointed by transfer. Lord, there is an affidavit, Lord, which contains all the these details. I may be permitted to file, my lord. We have sent, my lord, a copy of that to the Dharwad bench also, and we had requested, my lord, that could be
Madam,
made available to the honorable court. It's a 6-page affidavit, my lord.
Get to place it.
It was sent to the registrar by mail, and we requested it to be placed before the honorable court.
Today you have sent.
No, my lord. I think 2 days back it was sent.
Now we want to know, Mr. Sriranga, now
Yes.
they are the people of which batch? They are the people of which batch?
Lord,
The appellants.
Lord, so far as the persons, my lord, who are now before the court, claiming that they have a right to be considered prior to the direct recruitees, my lord, they were appointed on on 7/2/2011. So they are 2011 batch ABT engineers.
2010 are appellants.
Now,
And
have
direct
you-
recruitees.
Have you promoted persons who are of the earlier batch?
Not yet, my lord. 2007 batch. I have mentioned, my lord, in this my lord, my affidavit, that even 2007 batch, when we called for details from the 2007 batch employees, direct recruitees, and 2010 batch direct recruitees, there were series of my lord, writ petitions filed, and there were orders not to precipitate. And therefore, my lord, till today, even the 2007 recruitees, my lord, who were direct recruitees, they have not, although they got eligibility for consideration in the year 2015, their my lord, promotion could not be considered. And only in 2021, after, my lord, Pavitra 1 and 2 and order of this honorable court in Gurumurthy's judgment, my lord, in 2021, they have been now placed on in charge arrangement. Para 6 of the affidavit, my lord, points out that 2/11/2021 is when, my lord, they got placed on in charge arrangement.
Why were they not promoted even though eligible in 2015?
Lord, there have been series of Lord,
Litigation.
even though, yes, there are 4 sets of litigation here.
What is the position today? What is the position today?
Lord, position, Lord, is that as on today, Lord, the direction of the learned single judge, Lord, is that they should be, there is a vested right in favor of ABT candidates, and that needs to be considered, and the order also says, my lord, that there were old vacancies. And with regard to that, it needs to be considered because of this situation, my lord, there is no promotion that has been granted in favor of, awarded in favor of anybody as on today.
Are there any other litigation other than this now?
My lord, apart from this, with regard to seniority, because of Pavitra 1 and 2, my lord, there were a series of litigation which did not crystallize the seniority list, because there was redoing of seniority list because of Pavitra 1, Pavitra 2 judgments of the Honorable Supreme Court. Then, my lord, there was a offshoot of that. There was a series of writ petitions before this Honorable Court, which has been decided by the learned single judge. Review was preferred against that. Recently, my lord, review was partially allowed and closed, and that happened, my lord, last year. So till now, my lord, apart from this, there is one senior ABT related appeal, my lord, writ appeal, which is also pending consideration. Other than that, my lord, to my knowledge, there are no other proceedings.
No, are those people who are claiming seniority are before this batch or the later batch?
Later batch. Later batch.
The one batch is prior batch also, my lord. There are senior ABT claimants, and there is one batch of writ appeals which is pending before the first court, my lord. Apart from that, there is no other litigation, to my knowledge.
So will that have a bearing insofar as this petition is concerned, this appeal?
Not directly, my lord. Here they are claiming specifically, my lord, because the gap between the persons from ABT getting eligibility and persons, my lord, who are with ABT with 1/3 weightage, and those getting eligibility so far as direct recruiters is concerned, my lord, there was a very small gap between the two. And by the time this process was, the inquiries were conducted, and my lord, all the information was gathered. In the meanwhile, there were writ petitions filed, and there was no process undertaken. And because direct recruiters also got eligibility in the meanwhile, and they are 400 above in seniority, so far as the seniority list is concerned, my lord, they will get considered. And that is the issue, my lord, which falls for consideration in the present proceedings. This affidavit has all the details, my lord, with regard to the position.
No, we are only saying their prayer is for promotion. Now, if 2007 people have not been promoted, what is there right now?
They will not get any right, my lord, is my submission as on today. Those figures are available, my lord, in the form of an affidavit. The para 5.
What do you say?
Please, my lord, my instruction is, my lord, that in 2021, my lord, 175, my lord, in-charge promotions were given, my lord, 175. That 27 direct recruit graduate engineers, 59, and 116 2010 direct recruits, my lord, including us, my lord.
Was it on regular basis?
In-charge promotions, my lord.
That's right. In-charge is something.
That is because of the direction issued, my lord. There was a direction from this honorable court. There's a direction from this honorable court to make only in-charge arrangement.
All substantial powers, my lord, and they are getting salary of the post of assistant executive engineers, my lord, with all substantial powers, my lord.
No, but these are of this, which batch?
My lord, in 59, 2007 direct recruit graduate engineers, and 116 of 2010.
10 batch.
Graduate engineers, my lord.
So are these promotions regular for all purposes?
Regular for all purposes, my lord.
Subject to the writ appeal, pending writ appeal, and since there is a direction to give in-charge, make in-charge arrangement, they have done the in-charge arrangement. And my lord, kindly see, my lord, 2007 batch, the left out cases are all because of pending departmental inquiry and for not passing the examination, departmental examination. My lord, in 2018, my lord, about 52 2007 batch were promoted on regular basis. But the rest of them who were there, my lord, about 20 of them
whose names were also included, they got eligibility along with us when the circular was issued. And they are the last 20% are the last 2007 batch persons. But now there are more than 161 vacancies available. And in fact, my lord, in-charge judgment has been made against the regular vacancies that are available, including, my lord, the 2010 batch persons who are placed under in-charge, my lord, by the order dated in November 2021. That is pursuant to the orders passed by this honorable court. Therefore, my lord, the contention that there were no vacancies, my lord, may not be correct. And having given 2010%, my lord, the in-charge arrangement, they could not have left out me because I became eligible much earlier to them. Can I show, my lord, one paragraph of the KPTCL, my lord? What is the past practice? Your lordships put a specific question that what is the past practice adopted by the KPTCL, my lord? Kindly, my lord, read appeal 360 of 2021, my lord.
We are just seeing this affidavit.
And I'll furnish relevant
They say, para 6, you see para 6.
Please, my lord.
I state that no
Page 5.
promotions were made and promotion by way of in-charge was made to 60
Yes.
assistant. 119 assistant in 2010 batch wide OM did. An in-charge arrangement will be regularized prospectively. So if it is prospective, so you can't get it from a back date.
No, my lord, we are getting the salary of assistant executive engineer. Just 1 second, my lord, 1 second, my lord. And we are getting, we have got all the substantive powers, my lord, of the assistant executive engineer.
Obviously, you should have powers. What is the use of holding a post without any powers? You see, the system has to work, na?
Please, my lord.
System has to continue. So
Please.
they will give you powers. Even they will give you disciplinary powers.
Please, my lord.
But the fact remains, see, this is not what, this is what they say. We want to have your reply.
Please, my lord. Just now I received this copy of this affidavit, my lord.
What they say is, we have made 60 2007 batch, 119 2010 batch.
Please, my lord.
And we will make all this promotion prospective with effect from 21. So what is the effect thereof? Even a person who is appointed in 2007, his promotion as AEE would be from 21.
Please, my lord.
Not from a back date.
Even 2007 batch directly.
That's right.
Yes, my lord.
That's what they say.
Please, my lord.
If that
Yes.
be so, what is your relief? What are the prayers you are claiming? You should get promotion.
Please, my lord.
From which date?
Please, my lord. May I submit, my lord? Lord, these 2007 batch 60% who are promoted, my lord, they were not eligible as on the date when we became eligible. From March,
No, forget now, everything is now
Lord,
academic in the sense.
Lord.
They have taken a stand, the respondents, official respondents.
Yes, my lord.
All these promotion would be made regular with effect from 21.
Yes, my lord. My lord, my submission is this, my lord. Since 2007 batch were, my lord, not promoted as on the date when the others were promoted, they got eligibility only in 2021 and therefore they want to promote them in 2020. That cannot be a ground to deny me the promotions, though there were vacancies available in 2018.
Right? Can you have a prior right than 2007 people?
Definitely, my lord, when they are not eligible as on that date,
2007 or 10?
2007 batch.
How do you say so?
That is because, my lord, I have produced material to show that these 2007 batch who were not been promoted in 2018 were all promoted 2021 because their promotions could not be considered for pendency of the departmental inquiry for not passing the departmental examinations.
All these 60 people?
Yes, my lord.
All these 60?
Yes, my lord. I will bring the records and I will place it before your lordship.
No, then, so
Cannot be
what
correct.
follows from your submission?
Yes,
is
ma'am.
There are 2007 batch people who earlier got promotion.
Yes, 2018, 16 for 2018, 52% were promoted.
What is the total strength of theirs?
My lord, the 52 plus 60, my lord, 112 according to my calculation.
So these are the people because of this departmental inquiry, everything.
Yes, my lord.
And you are from 2010 batch?
Yes, 2010 batch, my lord.
You also?
I am from I was ABT, my lord. I joined the AE cadre in 2011, but I got eligibility much prior to these persons, 2010 batch persons. Therefore, my claim has to be considered prior to theirs. My lord, promotions in terms of the seniority, my lord, that regulations provides, my lord. And what is the past practice, my lord? I may be allowed to read only 2 paragraphs.
See, you are saying that, that's what we wanted to convey to you.
Please, my lord.
Can seniority be the only criteria without eligibility being there?
Seniority cum merit criteria is there, my lord.
Right, seniority cum merit means if 2 persons merit being equal, the senior person who is senior would get it.
Please, my lord.
That's the concept.
Please, my lord.
So we want to understand from you that if seniority, you have the seniority,
Please, my lord.
but if you don't have the eligibility,
Eligibility.
can you still be promoted?
My answer to your lordship's query, my lord, that the ABT engineers, if they fulfill the seniority criteria, my lord, and if their length of service is less, my lord, then their 1/3 subject to 4 years shall be taken into consideration for promotion.
Let's assume so. After taking 1/3, will they meet the eligibility?
If they fulfill the seniority criteria, my lord.
Seniority, let's assume that you are senior.
No,
Let's
I am
assume-
talking about the ABT engineers, my lord.
Very well, let's assume. For
Please, my lord.
They will very well. Now, between both of you,
Please, my lord.
between both of you, if they are junior engineers with counting of that service,
Please, my
1/3 or whatever,
Please,
they get the eligibility.
please, my lord.
You also get the eligibility?
No. Much prior to them, my lord.
No, no.
Because in terms of seniority list, we are not only 1, 2, 3, my lord. There are more than 500 ranking above, my lord. So their promotion will affect more than 500 engineers, my lord.
Okay, I think this requires more detail. What do you have to say on this affidavit?
But
I'll
File the
file
reply
my
to this,
counter,
my
my lord. I'll file my counter along with the documents to show.
To this?
Yes, my lord, because my lord, 2007 batch, the persons who were subsequently, my lord, given on in-charge basis were all because of they being not eligible to be promoted as on the day when I became eligible.
You show us from statistics?
Yes, my lord. I will show up with the material, my lord. I may be permitted to produce along with the records, my lord. I have already prepared the counter.
You also file it.
Please,
Yes.
please, my lord.
No, the para
Yes,
5
what
at
is this?
page 4. Para 5 at page 4, my lord, has all the statistics with regard to how many people were there from which batch as on 22/3/2018. Those statistics I have given, my lord. Totally, there were 499 eligible graduates
See,
from
we
all
want
batches.
Mr. Ranga, we want total statistic. What is the cadre strength? What are the promotion rules? We are
Yes.
concerned with which batch, how many vacancies were there when, how many were eligible, how many have been promoted, how many could not be promoted, the reasons thereof, when did the appellants get eligibility, when did the respondents get eligibility in terms of the recruitment rules. All these details must be there.
Yes,
Just say this.
that I will provide.
The official respondents, there is only one appeal, huh? One appeal.
Not, this is my appeal is 362 of 2000,
You are giving just made a combined order.
which I am the appellant.
Combined order has filed an additional affidavit. Yeah, just say this, the appellants in WA 362/2021 has filed an additional affidavit. A copy thereof has been given to the councils appearing for all the parties in this batch of appeals. They have also filed synopsis. Synopsis which
Of
are also,
submission.
which is also taken on record. The councils appearing for the appellants oblique the officers seeks and are allowed how much time?
Lord, 2 weeks time, Lord.
Which is the other appeal? Just show me that. Yeah, just say this, the appellants in WA 488/2021 and the private respondents in the said appeal.
All the appeals.
In both the appeals, seeks and allowed how much time?
2 weeks, my lord.
2 weeks to file response to the affidavit filed by the appellant in writ appeal number 360 of 2021. they shall also, the private respondent shall also file their written submissions along with the judgment they want to rely upon in both the appeals. The appellant oblique private respondents as a. Okay.
My lord, one more indulgence, my lord. 16th, your lordship, if can give the date.
We can't accommodate you on 16th.
Why, my lord?
Don't ask why.
Sorry, my lord, then 19th, my lord.
We will give you a date.
19th, my lord. 16th is holiday here.
We will have it on, this has to be Friday, no?
Yes, it has to be on Friday.
20. No, not possible. We can have.
Need not be specifically Friday, my lord, but normally its convention is it's Friday. Otherwise,
It is on Friday only after
whenever
2:30,
convenient,
all the
bench.
Lord, I
benches
have
constitution will be done.
I have difficulty
Friday
Monday, Friday because the Supreme Court miscellaneous day, my lord. Therefore, I was making request, my lord.
It's not possible on these 2 dates. Let's have,
Then 20, my lord, 20th, 21st, my lord.
you want Monday, you don't want Monday, Friday?
Yes, my lord.
Right.
21st, 22nd, my lord. Of
23rd.
August.
We'll have it on 27th.
Oh, 27th, my lord. Again, there will be miscellaneous day in Supreme Court, my lord.
Odd miscellaneous day you will have. If you miss one miscellaneous day, what is there?
Let it be on Friday, if possible.
Friday? You
Yes.
want to have Friday?
No, my lord, 27th, my lord.
The Friday benefit will be next day, Saturday.
No, 21st, 22nd is not possible, my lord.
Possible.
Then your lordship make it 28th, 29th, my lord.
Okay, very well. 28th.
Please, oblige, my lord.
The Friday, second half, maybe that may
Yeah,
be
we
better.
will have it second half. You have any difficulty there?
No, Fridays are better because
Fridays are better.
we don't know.
Then we'll have it on Friday.
Please.
30th, 30th then.
Great.
Thank you.
Not if it is on a Friday, let it be on 16th or 23rd.
Not possible, please. We'll have it on that. Okay, just take this. Thank you, brother.
Yes, thank you. In the meanwhile, Sriranga, just verify that whatever.
Yes, no. I will ensure that it reaches.
Please.
Great.